today with the panel titled Legal Constructs and Complications. As we know, especially from the discussion yesterday, there have been many complications to cover. So without going further on that, I would like to introduce our first speaker, Professor Seema Shah. Seema is the Associate Professor of Pediatrics at Northwestern University Medical School and Associate Director of the Bioethics Program at Lurie Children's Hospital. And Professor Shah.
Hello, sorry, I'm just getting my screen set up. So I wanted to, and let me show my video. Ooh. Okay. So first I wanted to thank the conference organizers and Jessica in particular. Christos, you've done a really phenomenal job of making this run smoothly and helping us actually make progress on this very difficult, very controversial topic. I also think it's unique in the sense that it's so cross-disciplinary. So I've made an effort to try and take some of these legal concepts and translate them, and also just have a lot of humility in recognizing that there are limits to my knowledge here, that we really do need to work across disciplines. So first, I really wanted to acknowledge that what I'm going to talk about, the idea of legal fictions, is something that a lot of people have widespread discomfort with. So even from very early days, Jeremy Bentham said a legal fiction is a willful falsehood having for its object the stealing of legislative power. And he was sort of thinking that courts, when they create these, they in essence are legislating, which is not what their role is supposed to be. And in the President's Council on Bioethics report, and many other documents from the bodies that have looked at this question of brain death, many people, including Meilander, noted that we should not create legal fictions or social agreements whose aim is less an accurate determination of death than a ready supply of organs. So there's been this long-standing distaste and discomfort with legal fictions. And I think it's important to take a step back and recognize that legal fictions are not exactly as many people who are so uncomfortable with them have understood them. So just to clarify what legal fictions are and why they're used, Lon Fuller, who wrote the book on legal fictions, argued that a legal fiction is a statement that is at least partially recognized as false, but is used as a legal tool. That is usually to ensure a consistent legal conclusion. Or another way that he mentioned they work is that they're sort of the temporary scaffolding of the law that can extend existing law to new circumstances that were not contemplated by the people who drafted the law in the first place. So legal fictions can often be useful when scientific developments or technological developments outpace the development of law. And I also wanted to make clear why I think it's helpful to think about brain death as a legal fiction using terms from outside the legal discipline. So I think the first and perhaps most important use is that legal fictions can provide a descriptive account or a legal diagnosis of what's going on with whole brain death. And in my view, and I think surprisingly, I felt a lot of people were stepping up to this yesterday as well. The way that the gap between brain death in the way that we determine it and what the statutes actually say is an unacknowledged legal fiction. But it can also be useful as a normative proposal for an approach for temporary legal reform. And this, I think, would require acknowledging the fiction and setting limits for it to be solid, normatively speaking. But I also think it's critical that this is temporary because legal fictions are scaffolding. They're not an actual extension of a building. So this comes from a few articles I've written with Frank Miller and a chapter that I wrote together with Frank and Bob Trug in their book. And I'll just, I wanted to just acknowledge, to put these up, and then I'll try and explain my position on this and acknowledge what both Frank and Bob have taught me. So what I'd like to do first is just talk about fictions and brain death, then explain how this relates to legal fictions. I want to touch on the dangers of legal fictions, which I haven't spoken about as much to this group. I was trying to think about how to extend beyond the last time I spoke about legal fictions to many of you at the conference at Harvard, and realized that in speaking with a colleague, Erin Paquette, that this is one key issue that we need to be thinking about, how they might be dangerous. Then I'll talk about legal fictions versus legal statuses. Finally, the importance of reform, and then briefly we'll touch on the analysis and what it means for the reform proposals that were discussed yesterday. So traditionally, and I will go very quickly here because I think this was covered in great detail yesterday, the legal consequences for determining death and initiating death behaviors weren't very time sensitive. I think Bob Veach was the one who described this term death behaviors. And they include things like funeral rites and disposing of assets or conducting homicide investigations. There wasn't a need to have a precise timing of death to do these things. But with the advent of modern technology, there were new reasons to care about the actual timing of death, including organ transplantation and the costs and burdens of long-term care of irreversibly comatose individuals. So in 1968, the Harvard Ad Hoc Committee, as we've talked about, set out new criteria for death. And I think it's important to just recognize the reasoning they gave was first to stop treating people with irreversibly damaged brains who burden their families and hospitals, and to avoid controversy in obtaining organs for transplantation. So they did not give a principled reason for a new way to determine death. And this is really one reason I think there were early doubts about the biological basis of these neurological criteria as a new way to think about death. And Beecher, in his lectures and writings, was really mostly pragmatic as he talked about it, but he also expressed some ambivalence in his writing, as Bob True mentioned earlier. Robert Veach also argued for multiple meanings for the term death as far back as 1976, arguing that there might be a social meaning as opposed to a biological meaning, and I'll come back to that at the end. And Hans Jonas and Wickler and Stiegler argued about the incoherence of brain death before 1982, focused on the cases of pregnant women who were able to gestate babies after a diagnosis after being determined to be to satisfy the neurological criteria for death. So the Uniform Determination of Death Act, as we've all noted, has these two parts, and it's worth noting the language is very strong in the second, the irreversible cessation of all functions of the entire brain, including the brainstem. And as we've discussed, so I'll just say this very quickly, just to make sure anyone who's joining for the first time today is on the same page as the rest of us. The evidence is now clear that brain dead patients have continued brain function, including hypothalamic function. And as Ari Jaffe noted yesterday, that occurs in 50% of cases. And these individuals can do things that do not seem like death to most people. They can preserve a warm body temperature, heal wounds, fight infections, mount stress responses, gestate babies successfully for months, and go through puberty. So I think there are two fictions here, and there's one that's relatively uncontroversial. And many people said this yesterday, including people who, like Jim Burnett, where I was pleasantly surprised to see that. And this is the problem, that there's a mismatch between the criteria and the tests. The current clinical tests for brain death do not meet the legal requirement of establishing the irreversible cessation of all functions of the entire brain. And there's a more contested fiction, which I think some of the people on the panel agree with and others do not. But this is the view that whole brain death is simply not the same as biological death. And the problem is that without having whole brain death as a legal category, brain dead patients can't legally agree to vital organ donation. Also, transplant teams could be prosecuted for committing homicide under state law. So the consequences of this are significant. Now, there are different types of legal fictions. There can be legal presumptions. For instance, under common law, the husband of a child's mother is presumed to be that child's father, and that may, as we all know, depart in some cases from biological reality. The type of fiction that I generally focus on in talking about brain death as a legal fiction is a fiction based on an analogy, or what I call a status fiction. So you treat B as if it were A, even though these are different things, so that the law governing A extends to B. Now, there are different types of status fiction, so to clarify or make it clear what we're talking about, probably the most famous status fiction is the status fiction of corporate personhood. So this is the idea that corporations are treated as persons under the law. And the law, where it refers to persons and their rights and duties and responsibilities, that can simply be extended to cover corporations as well as individual people like you and me. So this allowed courts to take an existing body of law, and instead of rewriting new statutes that would apply to corporations, just take the existing body of law and apply it to corporations. And I'll talk later about how this can be dangerous. There also is an interesting fiction of civil death, which was a fiction used in early English common law, where when people joined the clergy, they were determined to be dead civilly, so that their assets, which they could no longer do anything with once they were part of the clergy, could then be distributed to their heirs as if they were dead. So it's interesting. I think Jim Burnett used this term, civil death, and this is kind of maybe the closest analogy I can think of for what we're doing today with brain death. So in terms of whole brain death as a status fiction, the idea behind why I think this is a reasonable diagnosis or description of what's happening is that someone who is determined to be dead under neurological criteria is like a corpse, in that both have lost consciousness and the ability to interact in any meaningful way with others and the outside world. And as Frank Miller and Bob Trug have argued in many places, brain dead patients are therefore as good as dead for certain but not all purposes. I think it's also important to note that a legal fiction like this, if it's going to have any normative force, has to be ethically justified. So the use for donating, determining someone to be brain dead and then allowing donation from that person requires valid advance or proxy consent for organ donation, and if that's in place, then donors are not wronged. And if there's a prior decision to withdraw therapy, then death comes earlier. Family members have less time to say goodbye, but there are minimal harms from determining someone to be brain dead. Mike Nair Collins has forcefully argued that this first condition about whether donors give valid informed consent, it's really not clear that this is happening under our current system. But I do think that these ethical conditions are important to be in place. Additionally, if we have a fiction that isn't really based on some scientific fact, then there is some value-based component of it, then there's a need for reasonable accommodation or exemptions. And as we've discussed, there are 3 states that allow for reasonable accommodation: California, Illinois, and New York. And 1 state, New Jersey, that actually allows for exemptions from the determination of death. So one objection to using legal fictions in this way is that legal fictions can be dangerous. So some people have questioned whether legal fictions really can remain fictions over time, or if they acquire the patina of fact. Do they take on the authority of history because they've been around for so long that all of a sudden the fiction isn't as clear? And what some scholars have argued is that there's a difference between benign fictions and dangerous fictions. So the idea is that a benign fiction has built-in reminders of its fictional nature, while a dangerous fiction does not. So if you're going to use legal fictions, they argue they need safeguards against uncritical excessive use to make it clear what the analogy is and what the limits of the analogy would also be, so that judges can use legal fictions only for purposes that were intended by the doctrine. And corporate personhood is a really important cautionary tale in this regard. So Citizens United in 2011 was an important case where the Supreme Court granted corporations free speech rights. And this has been widely criticized in the popular press and many political cartoons for diluting individuals' free speech rights and allowing outsized corporate influence on elections. Of course, there's a pretty strong partisan divide in the views on whether Citizens United was rightly or wrongly decided. But what's interesting is that some scholars have argued the problem is that the limits of the analogy between corporations and persons really wasn't addressed by the court. So one scholar asked, who owns the corporation? Who gives the corporation its speech? And how and when does the corporation get the right to speak? Another scholar pointed out that if you simply extend rights to corporations as if they were natural persons, that ignores important differences and complexities about corporations. So there's a legal separation between the corporate entity and its shareholders, and the shareholders don't actually govern a lot of the decision making of corporations. Additionally, the scholar points out it's crucial first to recognize that the corporation is not homogeneous, but it's characterized by internal dynamics and potential competing interests in a way that goes far beyond how individuals might have internal dynamics or competing interests. So what this suggests is this analogy, this fiction, has been taken too far. One other approach to figuring out how to address the determination of death would be to consider using a status rather than a fiction. So Bob Trug and Frank Miller have suggested maybe we should consider brain death a legal status, like legal blindness, where people are on a spectrum in terms of their ability to see. And there's a line that's drawn beyond which people are determined to be legally blind or declared to be legally blind and to have that status. So according to Black's Law Dictionary, a status is a legal position or condition that entitles a person to certain rights or privileges or imposes certain duties. So it creates a legal category where you treat A as if it were B, not despite its falsity, but based on a social conception of a particular category. So in this way, a status doesn't necessarily depend on something being false and then just using the analogy, but it's rather a way of designating a category or drawing a line. So comparing the two, I think in general, a legal fiction, as I've tried to argue, it's where the law treats brain death as death. But a legal status involves conferring rights, privileges, and duties that would be related to brain dead individuals. And a legal fiction reasons by analogy, legal statuses are drawing a line and creating a category. Now, in terms of which is better for brain death, I think legal fictions are harder to understand. As I mentioned, there's this kind of instinctive reaction where people just don't like them. And this may drive a need for reform and transparency as opposed to holding on to the fiction. A legal status may be easier to understand and therefore harder to change or reform if that becomes necessary. Finally, legal fictions can be created by courts or legislators, and this could therefore be done by judges in individual cases or by the Uniform Law Commission, which, as many of you know, is currently reviewing the Uniform Determination of Death Act. Legislatures would have to codify a statute in a status in a statute. And so this would need to be done by the Uniform Law Commission and then adopted by states. So there are clear consequences, I think, of just sticking with the fiction and maintaining it without acknowledgement. I think if we continue obfuscating what we know and don't know about brain death, conflicts and cases will continue to accumulate, and more public groups may question whether brain death is a solid basis for vital organ transplantation. And I won't say more about that because I think some of the later speakers will be talking about this more. One other thought that I think is just relevant to this question, though, is can we rely on this idea of acoustic separation? I mean, this is a complicated area, these conversations that we have in the literature, especially in 1968, it's not clear that the lay public and the media was paying close attention to the medical or academic literature at that time. But today, I don't think there are many soundproof chambers where experts can discuss controversies and reach consensus in private. So I'm using this idea of acoustic separation from the famous article by Meyer Dan Cohen, where he talks about, he talks about it in the context of criminal law, but he says you could theoretically have cases where there are places where people don't find out about changes in law, and so you can make those changes without worrying about people gaming the system. But I would argue that even when you could have acoustic separation, it was problematic to make these determinations without engaging the public, given the values inherent in them. And it's simply just not possible any longer. So another objection was levied by Bob Veach, and he wrote an article specifically responding to the legal fictions account. So his view is that there are at least two meanings. Sorry, if everyone can mute themselves. I think I'm getting an echo. So there are at least two meanings for the word death, just as there are different meanings for terms like person or infant. And he proposed using sort of a social meaning of death. So he said, define the word death as the name applied to the category of beings who no longer have full moral standing as members of the human community with all the rights of that community, including the right not to be killed. So if this was done transparently, I agree that this is a plausible and defensible way forward, but it requires legal reform, and I don't think that this type of legal reform would be easy. It's not to say that it wouldn't be important or worth doing, but I just wanted to recognize that this is a pretty big task that Veach was suggesting. So I also wanted to finally briefly touch on the potential responses for reform discussed yesterday. So Jim Burnett talked about tightening the criteria for neurological determination of death, which would risk losing some or potentially many organs based on the evidence that Ari Jaffe was presenting. Or it could be loosened to brain as a whole criteria to account for what physicians are already doing. And I hope I'm getting this right. I'm glad that we can also discuss this. So if I'm misrepresenting what anyone said, please feel free to correct me. So this would account for the fact that physicians routinely ignore hypothalamic neurosecretion and random EEG activity. I think the problem here is that it's unclear what counts as the brain as a whole. It feels like it's sort of just defining things that don't fit current clinical criteria rather than conceptually creating a category and saying what fits within it and what doesn't. It's also unclear why hypothalamic function is not critical. So Bob Trug argued that we could treat irreversible apneic unconsciousness as a legal form of death, as is done in the UK, and then grant, I think a critical part of what he was saying based on the Q&A, but not based on his talk. So Bob, again, please correct me if I'm wrong, was that you'd have to grant exemptions if you were to change the determination of death in this way. And I think this could be a way to acknowledge the current legal fiction that is already in place. And this could be a temporary solution that is much preferable to our current situation where this legal fiction is not acknowledged. It could also be used potentially to create a new legal status if there was reform of the statute to include language to reflect this change. But I do think that this would be a profound shift to transparently treat the death of a person as a legal form of death. And it would, as David DeGrazia mentioned, create a form of death that only applies to human beings and not necessarily other biological creatures. So there are many, I think, who would argue that this is a problematic approach to determining death. Regardless, I think this is an important proposal for us to discuss. So finally, I just wanted to acknowledge that one of the issues that people talk about in legal fictions is that, is this issue of can you just take legal terms and define them as you please and have them be entirely divorced from reality? And Frederick Schauer argues that law, however technical it may at times get, must remain tethered to the language in which it was written and thus tethered to the language of the linguistic community in which the legal system exists. Were it otherwise, there would be no need for law. So I think what this suggests is that we need to maintain a connection to what ordinary people think of as death before officially endorsing a new legal meaning of death. So the takeaways here are that, as practiced in the United States, I would argue that the determination of death by neurological criteria relies on an unacknowledged legal fiction. And this means that the legal foundation for medical practice in determining death and conducting organ transplantation is unstable and is dangerous. It's time now, I think, to take advantage of the opportunity for reform by increasing transparency and recognizing different reasonable views on death, not by doubling down on the legal fiction. And I think there is more than one plausible way forward here. So I look forward to discussing some of these proposals for reform with all of you in the sessions to come. Thank you very much.
Thank you, Seema, Professor Shaw. Next, to build, really, I am sure, on what Professor Shaw just shared with us with regard to the Uniform Law Commission's work, we will be hearing from Professor Thaddeus Pope. He's from the Mitchell Hamlin University School of Law. And I believe that he was one of the creators of the health law program there. And he is my colleague on the book, The Right to Die. So welcome, Professor Pope. We look forward to hearing from you.
Thank you. All right. All right. So my title is, Should the UDDA be Modified? So I want to start back in 1968, right? This was, of course, the year in which the Harvard Committee published its report in JAMA. And in that report, they noted that no statutory change in the law should be necessary. Whatever else you think about the rest of the report, that was just wrong, right? Then, as now, clinicians are very risk averse, right? They want certainty and clarity. And that was especially true of transplant surgeons who wanted to know that the patient was already dead and they were not causing the death by doing the transplantation. So after 1968, the states started passing brain death laws. Unfortunately, during the 1970s, the states passed 6 or 7 different versions or types of brain death law. And that was just thought to be really bad, in fact, intolerable, right? Because it meant that you could be dead in one state, but not dead in another state. As the Uniform Law Commission described the problem, one's status as alive or dead should not depend on the capricious question of immediate locale. Now, in many areas of health law, bioethics, public policy, we tolerate and even encourage diversity and variability. So take medical aid in dying, for example. Some states permit it, other states prohibit it, right? But death is different. Death is more consequential. So from a medical perspective, right, death matters, right? We need to know, when can we stop life-sustaining treatment? When can we start transplantation? From a legal perspective, and Seema hit on this a little bit, right? We need to know when health insurance can stop paying and when life insurance should start paying. We need to know when estates are inherited and the money is transferred. From a criminal perspective, if somebody was attacked, is it murder or is it just battery? Is it wrongful death or is it medical malpractice? Right? And from a family perspective, right, the family needs to know when to grieve. When can we bury the body? So it's thought that uniformity, clarity, and certainty are especially important when it comes to knowing when somebody is alive or dead. And so in 1980, we get the Uniform Determination of Death Act, the UDDA. right? Which says that there are two ways to determine death: by the irreversible cessation of circulatory and respiratory functions, or by the irreversible cessation of all functions of the entire brain. Now we're going to focus on that second newer prong, which basically says that brain death is death, or to use the President Council's term, that total brain failure is death. Now, if you look at the legislative history of the UDDA, which is well captured in the President's Commission report, a key objective, if not the key objective of the UDDA, was to eliminate the variability of the 1970s. And what I'm going to show you in this talk is that right now in 2021, it's like it's 1979 all over again. There's a lot of variability, right? There's variability from state to state to state in exactly how brain death is measured and assessed. There's variability from hospital to hospital to hospital within a single state. And there's variability from clinician to clinician to clinician within a single hospital. And there's variability between law and practice. All of this creates a significant amount of uncertainty and confusion, and that manifests itself in quite a lot of litigation over the past few years. So here's my roadmap in just two parts. First, I want to describe for you 4 legal attacks on brain death, and then how a revised Uniform Determination of Death Act, in our UDDA, can help solve some of the problems. Okay, so attack number 1, right? We've heard that probably the most authoritative criteria for diagnosing brain death come from the American Academy of Neurology. The charge here is that the AAN doesn't measure what the UDDA requires, right? And we heard a lot about this in session 3. Seema referenced it just now. So again, the UDDA requires that you determine the irreversible cessation of all functions of the entire brain. But we know that brain dead people still do stuff, right? Pregnant, dead women can gestate a fetus. And we heard about the work of Alan Schumann, that dead people can heal wounds, fight infections, mount a stress response, grow, sexually mature, and regulate temperature and other functions. It appears that the AAN measures the cessation of only some functions of part of the brain, but the law, the UDDA, requires measuring the cessation of all functions of the entire brain. There's a gap between the medical criteria and the legal standard. To put a finer point on this, in 2019, the AAN issued this position statement. And in there, they said that the patient can satisfy their brain death guidelines, so they're dead, yet neuroendocrine function may be present. And they said that that's okay. It's okay to declare somebody dead despite ongoing functions of the pituitary gland and the hypothalamus. And that's not inconsistent with the whole brain standard of death, except that it is. We heard about this multiple times yesterday in the talk by Jim Burnett, the mismatch, in the talk by Bob Trug, in the talk by Dr. Jaffe. And just a few days ago, there was a survey of 200 Mayo Clinic clinicians, and they asked them, do you believe that when you get a positive result upon performing the AN test, that means that there's been a loss of all functions of the entire brain? The overwhelming majority said, no, I don't agree with that. So I want to just frame this as a legal and public trust problem. The UDDA requires irreversible cessation of all functions of the entire brain. And the pituitary gland and the hypothalamus are part of the brain. So it appears that people can be medically dead, but not legally dead. The medical criteria just don't require the cessation of all functions. They require the cessation of, we might say, just critical functions. And the problem with that is that the medical profession has moved the goalposts on what exactly is death. And whatever you think about the validity of those criteria, the problem is that the medical profession lacks the authority to do that. And let me just use a quick analogy here, right? A few years ago in Montana, they experimented with not having numerical speed limits on the highways, right? So you could drive as fast as you want, so long as it was reasonable and prudent, which meant, though, that the police in Montana had the discretion to determine whether or not you were driving too fast, whether or not, however fast you were going, whether that was unreasonable and imprudent. That's not what we have here with the UDDA, right? The UDDA gives us a standard, right? And it delegates to the medical profession only the job of measuring the satisfaction of that standard, right? It did not delegate to the medical profession the discretion to invent or create the standard in the first place. So that's attack number one, the mismatch between medical and legal standards. Attack number two, which guidelines should clinicians use to determine brain death, right? The UDDA says, make the determination in accordance with accepted medical standards. But there's a lot of variability out there, right? And this has been studied and measured again and again by the top neurologists in the top journals, right? Just look at the titles: variability of brain death policies in the United States, improving uniformity in brain death determination, variability of brain death determination guidelines, variability in reported physician practices for brain death determination. And this all came to a head in a court case out of Reno, involving this patient. And what happened was she suffered a catastrophic brain injury during an exploratory laparotomy. And clinicians then determined that she met the AAN criteria for brain death. But her dad disagreed, says, no, she's not dead. So he takes this to court in Reno, and he loses. And why does he lose? Because all the treating clinicians come to the court and tell the judge she meets the AAN criteria. So the court says, well, if she meets the AAN criteria, then she's dead. The dad appeals this up to the Nevada Supreme Court, where he wins, right? Why does he win? What does the Supreme Court say? They say it's irrelevant that the patient meets the AAN criteria because they're not the right criteria. It's unclear that they are accepted medical standards as the UDDA requires. And so Nevada had to amend its UDDA to clarify that the AAN criteria are the authoritative criteria to use. New Jersey, by the way, has done the same thing, and Oklahoma has a bill moving. It already passed the House. It's in the Senate now to do the same thing right now. So that's attack number two. Which medical standards are authoritative? Attack number three. A lot of families want a religious exemption. And as we heard, they have that in New Jersey, right? Where the law says death shall not be declared on neurological criteria if that would violate the patient's known personal religious beliefs. Now, so if the patient has a known religious objection, you can't declare death on brain death criteria. The patient may satisfy brain death criteria, but you can't declare death until the patient satisfies cardiopulmonary criteria. Now, in 1991, when the New Jersey law was passed, cardiopulmonary death would follow brain death relatively quickly in just a matter of days. But now, because of improvements in ICU care, cardiopulmonary death doesn't follow brain death often for months, and in some cases, even years, right? As in the case of Jahai McMath. Now, this idea of an exemption, religious exemption for brain death, has been rejected everywhere outside New Jersey, but it's still asked for a lot. So Kathy Sermonauer yesterday mentioned this recent Texas case involving Nick Torres. And in fact, Texas now has a bill in the current legislative session to basically offer religious exemption, just like New Jersey. There was litigation late last year in California involving this patient in the federal appellate courts. Basically, the parents were suing the state of California, saying, we have firm religious beliefs that so long as the heart is beating, the patient's still alive. And therefore, when you remove cardiopulmonary support, that's an unconstitutional interference with our freedom of religion. You have a lot of other cases across the country just like this. CHOP, Children's Hospital of Philadelphia, had 2 cases a couple summers ago involving this patient and this patient. There was an Orthodox Jewish family at Children's DC, a Muslim family in Michigan, a Buddhist family in Massachusetts. And there have been even more recent cases at the end of 2020 in New York, Michigan. And I'm speaking to you right now from Ottawa, and there have been 3 or 4 cases like this here in Ontario. And we're going to see more of these cases. Why? Because there are pro-life advocacy organizations with the money and the mandate to push this. So that's attack number 3. Should there be a religious exemption from brain death? Attack number 4, must clinicians get consent for brain death tests? So some families try to prevent the brain death diagnosis. Why do they do this? Well, what are clinician duties after brain death, right? They're really, really limited, right? Families really don't have any post-brain death treatment rights. So they focus on their pre-brain death rights. And the focus is often on the apnea test. This is the final confirmatory test, right? It's built into the adult guidelines. It's built into the pediatric guidelines. But what's happening is you have a lot more family refusals. Most of these are pediatric cases. These are just some of them. And so we might call these parental refusals. So, right, so the parent is saying, no, you're not going to do that apnea test. Well, if you can't do the apnea test, then you can't determine that the patient's brain dead. And if you can't determine that the patient's brain dead, then your treatment duties continue until cardiopulmonary death. It's basically an opt-out of brain death. Practically speaking, it's the same thing as the New Jersey religious exemption. Why? Well, in New Jersey, you can determine death, you just can't declare it. Here, you can't even determine death, so you definitely can't declare it. So that leaves the question, must clinicians honor the refusal, right? Do clinicians need consent to do the apnea test? Well, the jurisdictions are just completely split on this question. So some states say yes. So in Montana, this is just, I'll give you one case example. Out of Billings, there's a little boy, he drowned, or according to his parents, almost drowned, right? He goes to this hospital. The clinicians do the clinical bedside exam, think that he's probably dead. They want to do the apnea test to confirm. Mom says, no, you're not doing that apnea test. Hospital goes to court, says, judge, we have a patient in our hospital. We need to know, is he alive or is he dead? It's a pretty fundamental question, judge. Court says, no. Your request permitting testing is denied. The mother has sole authority to make medical decisions, including brain functionality exams. So do clinicians need consent for the apnea test? Montana said yes. Kansas also said yes. In a case, another young boy drowning victim. California also said yes, yet another young boy drowning victim. And actually California said yes in a second case as well. So do clinicians need consent for the apnea test? Montana, Kansas, California all said yes. That's a plausible position. Why? Because normally you can't do things to a patient without consent, right? If you do, that's a medical battery. Other states said, no, you don't need consent. So Virginia said no, Nevada, New York, Georgia, and Texas. So we just have a split on this question, and the conflict continues. There's new cases all the time. So that's attack number 4. Do you need consent to do brain death testing? So to recap, right, there have been these 4 attacks, which has created variability and uncertainty. And remember, the whole point of the UDDA, the U in UDDA stands for uniform, right? The whole point of the UDDA was to eliminate variability. So what's the response to these 4 attacks? Well, the Uniform Law Commission, the organization that drafts uniform laws, is considering a revised Uniform Determination of Death Act, an RUDDA. And I'm just going to tell you this process here. Step 1 is to appoint a study committee. They did that last July. Step 2, the study committee meets and deliberates. That's happening right now, and a fair number of people on this meeting are on that committee. Step 3 is the study committee will make a recommendation. Should we amend the UDDA or should we not amend the UDDA? They'll make that recommendation by this July. If they make a recommendation to amend and the executive committee agrees, then the executive committee will appoint a drafting committee. And then the drafting committee will meet and deliberate. And maybe they'll talk about the things that I just presented to you about the medical legal gap. What are the accepted medical criteria? Do we need consent? What about religious objections? Maybe they'll discuss other things as well. And then they'll draft the RUDDA. If the executive committee agrees with their draft, that might happen by July 2022. And then it will be available for the individual state legislatures to enact. If that happens, that should reduce variability and increase certainty and trust, right? Some states have already moved forward on their own, like Nevada's already amended its UDDA. And like I said, Oklahoma is working on that right now. So to wrap up, there's a lot of variability in medical standards. There's a mismatch between the legal criteria and the medical standards. And there's a lot more conflict and a lot more litigation. That is probably hurting the public trust in the determination of death on neurologic criteria. And that can hurt the organ donation rate. Even though we've moved to a lot more to DCD, 75% of organs still come from brain dead donors. Mm-hmm. So to wrap up where I started with the 1968 JAMA article, like I said, they said no statutory change in the law should be necessary. They actually qualified that. And they said, you know, there is a circumstance in which it would be necessary that legislation be offered in the various states to define death by law. And that would be in the event that great controversy were engendered surrounding the subject. Well, that's where we are now. So the line between life and death needs to be bright and clear and sharp, but it's kind of gray and kind of fuzzy right now. And an RUDDA can help restore some of that clarity. Mm-hmm. Thank you.
Thank you, Thad. And now I have the great pleasure of introducing co-dean and professor of law at Rutgers Law School, Kimberly Mutcherson. Kimberly is a noted scholar of family law, health law, bioethics, and is addressing a very hot topic at the moment, law defining death and adding conscientious objection to the mix. Thank you. It's all yours.
Excellent. Thank you so much for that introduction, Kathy. And let me just make sure that I can get this working. All right. I'm not going to bore everybody by doing that thing we all do, which is, can you see my screen? I feel confidence here. So as Kathy said, my name is Kim Mutcherson. I am coming to you from my desk in my office in New Jersey. So I am glad to have heard our state invoked several times already. And I'm also grateful that I'm following Professor Shaw and Professor Pope, who I think really were great preludes to what I want to talk about. So I really describe who I am as a scholar in a number of ways. I write about family law, I write about health law, and I write about bioethics. But I really fundamentally consider myself to be a reproductive justice scholar, and I'm going to talk about what that means in just a minute. So it may seem a little odd for someone who focuses on reproduction to be at a conference that is fundamentally about defining death, but it actually makes a lot of sense for reasons that I'm sure are obvious to the folks who are participating in this conference today. In particular, though, I think once I've made sure that we're all on the same page about reproductive justice and what it means to be a reproductive justice scholar, it's going to make sense across the board. So in my time with you today, I am going to talk about the death of Jahai McMath, who I know was already invoked at this conference. And I'm sorry that I wasn't able to participate yesterday to hear some of that discussion. But I want to put Jahai's life and death within the framework of reproductive justice and give it a context relevant to what we are currently living through in the United States and globally, specifically a pandemic that is killing Black and Brown folks at a frightening rate, and an epidemic of police violence that the APHA has called a public health crisis. So within that context, I'm going to mine some of the lessons that Jahai's life and death can teach us, hopefully, about what it means to value or not value the life of a Black child or the lives of Black people in general. Now, as you know, the date of Jahai McMath's death is disputed, but what is not in dispute is the series of events that led to her death. She was a 13-year-old Black girl from Oakland, California, who was deeply loved by her family. She had sleep apnea and was scheduled to have surgery to have her tonsils removed, which would help with that problem. Jahai was accompanied to Oakland Children's Hospital by her mom on the day of her surgery. Her mom is Nyla Winkfield. And the 4-hour operation took place at that hospital in December 2013. When Jahai woke up post-surgery, a nurse gave her a grape popsicle to soothe her throat. And about an hour later, Jahai began spitting up blood. The nurses on duty indicated that the family shouldn't worry about the blood and gave Jahai a basin to catch it. Within a couple of hours, the bandages that were packing Jahai's nose had become bloody too. And her parents, as anybody could imagine as a parent, became very distressed by the volume of blood and repeatedly asked for someone in the hospital to do something. Jahai's mom, Nyla, recalled the feeling of having their concerns brushed off by the hospital staff and was later quoted as saying, quote, "No one was listening to us and I can't prove it, but I really feel in my heart if Jahai was a little white girl, I feel we would have gotten a little more help and attention." Eventually, a crying and distraught Nyla called her mother, Sandra, who had been a nurse for 30 years and worked for Kaiser Permanente in Oakland. So Sandra arrives at the hospital late in the evening, and she saw the amount of blood that was in the basin that the nurses had given to Jahai, and she too, now we've got a healthcare person in the room, also raises significant red flags. Medical records indicate that the nurses notified the physicians on duty on multiple occasions that Jahai was bleeding, but nothing was done about it other than continuing to observe her condition. And then at one point during their night at the hospital, Sandra actually asked a doctor who was in the ICU why they weren't doing anything about Jahai's bleeding. Sandra later recalled that the physician never introduced himself and said that he was, quote, all frowned up with his arms crossed, and that, quote, it was like he thought we were dirt, end quote. At 12:30 the next morning after the surgery, Sandra saw on Jahai's monitor that her oxygen saturation levels had fallen precipitously. She yelled for medical staff and several of them came running. Ultimately, Jahai ended up being intubated. She was put on a ventilator, and it took 2.5 hours to restore her heartbeat and to stabilize her breathing. 2 days after that, the hospital, the healthcare providers declared Jahai to be brain dead for all of the reasons, right, that brain death is declared. Her pupils didn't react to light. She didn't have a gag reflex, all of those things. And on an EEG test, she had no brainwave activity that could be detected. Despite this information, the family refused to accept that Jahai was dead. So she remained on that ventilator while her parents really struggled and her family struggled to come to grips with the fact that their child had gone in for what should have been a routine operation and was now legally dead, at least in California. Now, one would think that the level of sympathy these parents would have received from everyone at the hospital would and should have been absolutely through the roof. But the already extremely tense and distressful relationship between hospital staff and Jahai's family only deteriorated as the family refused to back down from their belief that Jahai was very much still alive, even if her care team did not share that belief. There were so many moments in the days that followed where the tensions between the family and the hospital were painfully apparent. And I'm just going to give you a few examples of those that I think are really quite striking. At one point, Nyla had a conversation with a Black doctor at the hospital who had asked to speak with her about preparing Jahai's body for an eventual funeral. And Nyla described her feeling in coming out of that conversation as feeling like she was being belittled. In her mind, the conversation suggested that the doctor thought that because lots of Black people in Oakland have to bury their children, that they, Black folks, were somehow supposed to be accustomed to the death of children and treated as something that Black people just normally go through. The second example I want to share is from a meeting between the family and David Durand, who is the hospital's senior vice president and the chief medical officer. And that meeting took place 10 days after the surgery. The family asked Durand to allow Jahai to remain on the ventilator until Christmas, and Durand refused. They asked that she be given a feeding tube, which he also refused because she was dead, according to the hospital. At one point in the meeting, and this is according to the family and their lawyer, and Dr. Durand disputes it, but according to the family and their lawyer, Dr. Durand became frustrated by their persistence in asking for further treatment for Jahai, who he was dealing with as a dead patient. And he said to them, "What is it that you don't understand?" He then pounded his fist on the table and said, "She's dead, dead, dead." Now, eventually, Jahai was moved from California, which, as we know, defines death in a pretty standard way. And she came here to New Jersey, which, as was already discussed, allows this carve out for folks who have religious objections to the concept of brain death. This case got a lot of media attention, unsurprisingly, and bioethicists had a bit of a field day, frankly, shaming the parents for their refusal to accept that Jahai was dead. Arthur Kaplan, for instance, in an op-ed wrote, quote, "Keeping her on a ventilator amounts to desecration of a body," end quote. Others, like Dr. Bob Trug, a professor of medical ethics at Harvard, acknowledged the incredibly troublesome tenor of much of the media coverage and admonished his bioethics colleagues for their knee-jerk response to support the traditional understanding of brain death, quote, "to the point that they were really treating the family with disdain." I'm going to do something weird here, which is wave my arms, because my light needs me to move in order for it to stay on. So Trug, unlike too many others, recognized that focusing on brain death and ignoring the race issues that were inherent in this controversy was short-sighted, and it missed an important and incredible opportunity to talk about the larger issue of Black folks and our healthcare system in our larger society. In particular, ignoring what we know about the abysmal cultural competency of far too many healthcare providers, the years of neglect that Black people have experienced in these countries' healthcare system, and the widespread and long-standing distrust of that system on the part of many Black people. Instead, the media and the bioethics community and much of the medical community focused on the parents' supposed failures and misunderstandings rather than those of the people who provided care to Jahai, especially in California. Nyla herself once pondered whether they would have pushed so hard against the brain death diagnosis if they had felt greater sympathy from the staff at Oakland Children's Hospital. And I think that's really important that she identified that. So I want to switch gears now and give that greater context that I said I wanted to provide. Now, as someone who does a lot of work on abortion, the idea of conscientious objection in medicine is a concept where I am often challenging the ways in which it is deployed, right? To refuse to provide care to someone who wants to terminate a pregnancy. But I recognize, as has already been said in this conversation today, that death is a legal concept, it is a medical concept, it is a religious concept, and frankly, it is also a political concept and a political phenomenon. And I get that it's powerful and often disturbing to some folks that the law can determine that death is a state that is set by religion instead of medicine and science. But without the existence of that law in New Jersey, Jahai's parents and her mom especially, who ended up living in New Jersey when Jahai was here, would not have had a way to assert her rejection, their family's rejection, and their objections to the care that Jahai was receiving in California. To the extent that race played a role in how Jahai and her family were treated in California, the remedy, such as it was for their family, didn't come in the form of any acknowledgement from her care team that race had been a factor in Jahai's treatment or lack of treatment. Instead, it was only by resort to a law that protected religious thought in the context of death that they were able to make choices that they wanted to make about and for their daughter. And the fact that so much of the discussion about Jahai ignored the issue of race is a real testament to the discomfort that so many in this country still feel with confronting racism and implicit and explicit bias. But if we can't get past race, we can't get past race by trying to simply leap over it. You have to go through it in order to emerge triumphant on the other side. So I want to talk about that. We are in a justice moment in this country in which so many of our failures have been laid painfully bare. As a reproductive justice scholar, I see how Jahai's life and death fit squarely within the reproductive justice paradigm. And for those of you who aren't familiar with that paradigm, here's what it is. That reproductive justice, which is a concept that was created by Black women in the mid-90s as a corrective, essentially, to larger reproductive rights discourse, which often ignored the issues that women of color, particularly Black women and low-income women, experienced in this country. And so reproductive justice was a way of thinking much more expansively about these issues. And what it stands for at its core is a woman's human right, it's human rights based, to decide if and when she'll have a baby, the conditions under which she'll give birth, to decide if she won't have a baby and her options for preventing or ending pregnancy, and then to parent the children she already has with the necessary social supports in safe environments and healthy communities, and without fear of violence from individuals or the government. And it's that last piece, I think, that really speaks to the expansiveness of reproductive justice and why it's so important, including in this context. And here's another way to think about reproductive justice. It is an intersectional theory emerging from the experiences of women of color whose multiple communities experience a complex set of reproductive oppressions. It's based on the understanding that the impacts of race, class, gender, sexual identity, oppressions are not additive, but integrative, producing this paradigm of intersectionality. And so ultimately, every mother, every parent deserves to be able to raise her children in safe and healthy environments. But here's what we know. We know that as compared to white people, Black people in this country have lower rates of health insurance. They have worse health outcomes across a range of diseases. We are more likely to die in childbirth or soon after. We are more likely to be medically infertile. We have higher rates of childhood asthma. We are incarcerated in this country at a higher rate. We are more likely to live in neighborhoods with higher levels of environmental hazards. We are significantly more likely to die in our first year of life. We are more likely to contract and die from COVID-19, in part because of increased rates of underlying conditions like diabetes. We are more likely to be low income and live in neighborhoods that are over-policed, and we are killed by police at a disproportionate rate. So when I look at pictures of Jahai's mom and I see her pain, I am reminded of all of the Black mothers in this country who have not been able to protect their children from violence in their neighborhoods or from the school to prison pipeline or from police brutality or from preventable illnesses or medical neglect and more. She joins a very long line of Black mothers who mourn children who are gone too soon because of racialized violence by private or public entities. Women like Mamie Till Mobley, who is the mother of Emmett Till, Gwen Carr, the mother of Eric Garner, Leslie McSpadden, the mother of Michael Brown, Sabrina Fulton, the mother of Trayvon Martin. And we have watched the epidemic of police violence remind us of the precarity of Black bodies, no matter our age. And then we also have to mourn the losses of far too many Black women, no matter their economic status, who go home from the hospital without their babies, or babies who go home without their mothers. And I need not tell you about the painfully disproportionate impact that COVID-19 has had in Black and Brown communities. So in the end, I'm dismayed by the extent to which Jahai's case has elements of being extraordinary, but is in fact painfully ordinary for Black people in America. And what do I mean by that? It's a story of pain, it is a story of loss, it is a story of grief. And all of those things, all of those emotions intertwined with the reality of multiple failed systems, including a deeply problematic healthcare apparatus that have yet to take serious account of the ways in which they perpetuate and protect racism and racial hierarchies. We can't claim to be anti-racist or claim to pursue reproductive justice in a world that is not safe for Black mothers or for their children, no matter the age of those children. Our systems must have strong advocates within them, people who are working from the inside, seeking to dismantle racial hierarchies that so often are to the detriment of Black people, Black parents, Black children, and Black families. So it's pretty somber there. So I want to actually end with something at least that's happy in terms of the picture. So this is a picture of me and my two children, Max and Josephine. And I count myself to be extremely lucky. I've got two beautiful kids who are, for the most part, quite healthy. We have access to great medical care and top-notch health insurance. We live in a safe suburb in New Jersey. They attend public schools that don't have metal detectors, and they have enormous opportunity available to them by dint of where they were born and the parents to whom they were born. But I know that unfortunately in this country, and we know this from the data, that economic privilege is never enough to protect Black people from harm when we live in a society that is riddled with systemic racism. So all I can do, frankly, is continue to do the work that I do in order to make these things visible and to potentially force people to talk about issues that make them uncomfortable, and also hope that the work that so many other people are doing will ultimately bear fruit, if not for our generation, then for my children's generation, and if not for their generation, then potentially for the generation that follows. So I'm gonna leave it there and make way for the next speaker.
Thank you, Professor Mutchison, Dean Mutchison. I am thrilled to announce that because of the efficiency of our speakers this morning, we will have a brief time for questions now before the break. So we will manage to vary the voices that we have going here, and we have a lot of wonderful questions, both from the panelists and the audience. So the first question, I believe, is from Professor Oz.
Yeah, hi. Hi, Seema. So I just have a couple questions for you. One might be relatively quick. So the first question is just, maybe you could say a little bit more about why a judge would be limited to creating a fiction as opposed to constituting a status. That's a jurisprudential question I just don't know the answer to. And then I just wanted to plump a little bit, and I don't know that this is a question because I'm not sure that you're actually in favor of fictions over statuses, but just to say something in favor of you know, if say we are going to stick with brain death of having it be a status rather than a fiction, it seems like in these difficult justificatory contexts, as in the case of Jahai McMath, if she had been brain dead, now it seems very clear now, or at least very possible that she wasn't, but if she had been, to say that we're going to disconnect life support from your child because we have this fiction we made up that she's dead, and you know, to transparently say it's a fiction is to say not just that we're saying that she's dead, but to transparently say it's a fiction is also say, oh, by the way, she's not dead because it's a fiction, right? A fiction is false, right? it seems like a weird way to justify behavior to someone in terms of a claim which you are in the very same breath asserting to be false, right? Especially such significant behavior. And so it seems like you might be better off in a justificatory sense saying, look, no, there's a sense in which she's dead. I understand there's a sense in which she's not, but there's a sense in which she's dead. And again, in the actual case, she wasn't even dead in that sense, but in a case where someone was brain dead, you can say there's a perfectly good sense in which she's dead, and I can explain it to you, right? It's actually true that she's dead, not false, but useful to say that she's dead. So I wonder if that's not, if you'd agree that that's a reason to go in favor of a status view, even if maybe there are reasons to go against it too.
Yeah, thanks, Sean. It's great to see you. Quick, I think these are relatively quick actually to respond to. So the first is judges deal with ongoing cases and controversies. So they're dealing with cases in front of them. They have to resolve those particular cases. They're not creating actual statutes that apply to a range of cases. So typically judges they're not writing the rules, right? They're applying the rules to specific cases, and then they have to decide whether that rule can be extended to a particular case. So a legal fiction is a way of saying, this case fits within this existing rule without changing the rule. And a status, in my mind, would require changing the rule. So that's the main reason that I think fictions are typically in the province of judges and not statuses. But I do think there's not a lot of legal work on statuses or the distinctions between these two. So, it's possible that there are other legal scholars who have different ideas about how to do it. The second question, I think that there's a distinction between what's the legal tool you're using and how do you talk to families about that tool. And I agree that fictions are inflammatory and not that helpful for talking about what it is that you're applying to a particular person's case. I think the way that Bob True spoke about this yesterday is, entirely within the realm of saying we have a current legal fiction, and he's acknowledging it and saying to families, your child is not going to regain consciousness, is not going to come back to you. I see that the law treats the state that your child is in as dead, and they're legally dead. That's a way of, I think, being honest about what's happening without using the language of a legal fiction, but still employing the tool of a legal fiction. So I think there's that's one key distinction. I would not advocate talking to patients and families about legal fictions. I think this terminology is both confusing and sometimes inflammatory, but I want to ground what we're doing in how the law has operated for a long time.
Can I follow up on the legal on that? Seema, is one consequence of moving from a fiction to a status the fact that we could unpack the concept? And what I mean by that is, like, the fiction, like brain death, is this all-purpose unitary concept. But when you're talking, it seems that a status, we could unpack it and we could say, well, there could be different standards for stopping life-sustaining treatment, procuring organs, burying the body, and those might all be at different points, or different. There might be different clinical states that would justify each of those triggers, and there might be others as well. Is that a consequence? And would that be okay to unpack it and to have, and to have different standards for each of those actions?
I think absolutely. I think you could do that under a legal fiction, right? So if you recognized its limits, that's one way of saying it doesn't apply to all cases. And that could happen with a fiction. So I think, some scholars have said if you can be really transparent about the analogy, and then you have to be transparent about the limits. So this analogy works in this context, but not in that one, just as you're saying. I think, however, it's less clear to do it that way than to do it with a status and then specifically say, brain death is something that's relevant for organ transplantation, but it may not be relevant for consent to research or something else like that. So I think that might be one way. I tried to speak about this in the paper where I talked about the limits of legal fictions, but I agree that a status could be a clearer way of drawing different categories that where the analogy makes sense and where it doesn't.
Thank you. Next question is from Professor Paquette, Aaron, and I think that perhaps a follow-up from Seema Professor Shaw also.
Thank you. My question is for Professor Pope, which is, what do you think of, you made a comment during your talk that the legal standard that is set gives discretion to the medical profession to sort of outline how to operationalize the definition of death, but doesn't give discretion to determination of the legal standard for death to the medical profession. And the question I have to follow from that is, how do we then think about the role of the medical profession, both in the initial drafting of the Uniform Determination of Death Act, as well as in its current consideration for revision? How do we think about the role of the medical profession? I'm sure as many of us who participate as observers have identified, the study commission is largely considering and being informed by experts within the medical profession. And so how do we think about that role and with regards to your thoughts, your comments?
So thank you. The first thing to say is, I guess I wasn't making a normative point about who should get to determine the standards for death. I guess the point is the UDDA was drafted 40 years ago, and it gives a standard, and it was very clear to delegate to the medical profession only the job of measuring the standard that's in the law, right? So that's just a current problem, right? And how do we fix it? We could, Bob Trug laid out these nice options yesterday, but we could, in the RUDDA, just say death is whatever the AN says it is, right? I mean, we could have a wholesale delegation of discretion and judgment and just defer completely to the medical profession. We could have done that back in 1980, but we didn't. I think it's unlikely that that's going to happen in the RUDDA because that's a pretty big change, right? And I think, again, this whole conference shows that this is not a purely technical, objective, scientific inquiry, but it's a value-laden inquiry. And therefore, it should be multi-professional and multidisciplinary. And so therefore, I think we're going to keep the idea there'll be a standard which will have broad public input, but there'll still be a delegation to the medical profession to come up with the right tests to assure hopefully nearly 100% accuracy in determining the satisfaction of the standard that's set forth in the law.
If I could follow up, I thought, so I think your presentation was really excellent and clear, Thad, but the thing that I'm trying to square and understand is you wrote that paper where you're proposing a particular way that the UDDA could be reformed. And I saw that paper as suggesting greater deference to the medical profession to set the standard. So I'm curious if that is your view or not, or if I didn't read it right.
Well, the one thing to say, which is obvious from the face of the paper, is that I wrote it with Ariane Lewis. So I think when you have co-authors, you come up with a paper. But I don't think that it says that. I mean, we had one in Annals of Internal Medicine and one in Journal of Law, Medicine, and Ethics. I like to think that we played a role in pushing the ULC to actually start the process of reconsidering the UDDA. I mean, that was the point of those articles. I don't think that I pushed. I don't recall that it pushed for that. I think what it was saying, in other words, it would keep the standard, which is irreversible cessation of all functions of the entire brain. And then we said, well, we're not now measuring that, right? So we would say, except the hypothalamus, right? And then we would bridge that gap, right? And then the thing that what the AN is doing actually matches what the UDDA says it's supposed to be doing. So, but we weren't going to just get rid of the language irreversible cessation. So I don't know that we push for a wholesale delegation.
Well, I guess what I'm saying is, if you take what the AAN is doing as what the standard should be, then the law is essentially adopting what clinicians are doing.
Well, no. So real quick, it could have said, death is what the AEN says it is, right? And that would be a wholesale delegation. But the idea was that it says, death is the irreversible cessation of all functions of the entire brain, and that shall be determined. How do we determine that? How do we measure it? What's the right way to measure the satisfaction of that standard? The AAN. So that's different, right? Because it means that the AAN has a leash, right? So like a dog, it can wander around and figure out what the right standards is, but it's on that leash, and it can't go too far because it's still anchored back to the standard, to the language that's in the UDDA.
Yeah, sorry. So I know there's so many questions, but I just want to be clear. I mean, I think you're right. There are degrees of deference. And I think part of the issue is what's the appropriate degree of deference. And my worry is that by sort of taking what the AN is doing as what should be in the law, that differs too much, that sort of carving out particular areas simply because that's current clinical practice without a clear justification, that to me is not really setting a legal standard.
Yeah,
Before you respond to that, can I just add one thing to what Seema said, because I'd love to hear your response to this as well. Not only is it deference to professional guidelines, but that there may not be recognition that any professional consensus panel, regardless at what scope it happens, there is a selection process by which that consensus panel gets put together. And there are necessary people who are in and out of that consensus group, right? So when we're thinking about how much deference to give to statements, whether they happen on the state scale, the national scale, the professional society scale, the world scale, if it's expert consensus, those experts undergo selection. So how do we think about that question as well, as we're thinking about deference?
All right. That I think that you're getting the lion's share here, but I think we have yet another one for you, Lainey. You had a discussion, I think, with that about.
So Thad, I was curious, why should a clinician at the bedside determine death if it's not going to be declared? So if you live in a state like New Jersey where families can opt out of the death by neurological criteria, why would doctors actually do all the tests?
So I think that's a clinical question. And I guess my point was not that they should, is only that they could, right? So legally, the unique law in New Jersey says you can't declare death. It doesn't say you can't determine death. So you may be right that if you're not going to declare death, then why bother to even do the tests? My point was only that legally you may and you could do them. I think Bob True noted in the comments that there might be good reasons to not do as maybe this is what you're suggesting. There may be good reasons to not even do the determination, because if the patient were transferred, so even the mere fact that the determination was dead could limit their insurance options and transfer options. So you may not want to even do the determination.
Just to clarify that point, it's that we make the determination of brain death to clarify to the family what the state of the patient is and that we are not going to continue to provide that treatment. But by not declaring death, we make it possible for the family to transport their patient. These are typically international patients, to transport the patient back to their home country, where very often life support is continued, in many cases for months or even years. So, and you can't transport a body after it's been declared to be dead.
But that doesn't distinguish that it's determined, right? Because so Thad's whole point was that you can't declare them dead, but you can still determine. So
and that's what we do.
Right. Well, do you actually do the apnea test? Okay.
Yes.
And you do that in order to tell the parents that we would not continue treatment, but you can before we declare it, you can move your loved one to your own country. Got it.
Correct.
Do you do that for
Yeah.
Americans too? Do you tell them, so if you want, you can move your body to New Jersey so that you
We
cannot
do.
be, okay. Consistently? Really?
At their request.
Okay.
We've never had
So,
anyone. We've never had New Jersey accept a patient.
uh,
But you've
so
tried to transfer.
We have done due diligence and we have asked everyone we know in New Jersey if they will accept the patient.
with that, I'm actually going to turn to our New Jersey resident. We do have some questions from the audience for you, Kim. First was Peggy Mason, who had asked about, let me see if I can find it. First was Peggy Mason, who had asked about,
I did see her question, Kathy, which was
Okay.
about whether anyone had done a study of
Yeah.
these cases and whether there was disproportional representation of people of color. I have not seen that. I mean, I think one of the things that's interesting in these cases is that some of them get wildly sensationalized, and so we see them all over the place. The other thing that I think is interesting is, and this is something that I talk about in my work in other ways, it's amazing what kind of pressure can be put on people so they don't necessarily end up in court because the interaction with the healthcare providers is such that they think I've got no choices here, and they get a little stuck. I would not be surprised that if somebody did do the work that they would find that there is disproportionality. So it's not totally analogous, but there have been some really interesting studies about, for instance, forced obstetric interventions, and those are sort of consistently focused on women of color. So.
and I believe some of our other panelists have indicated they are planning to work on such studies and may even be doing that right now. So there is one more that I think actually ties very well back to the conversation just before this, which was from Mary Devereaux. Thank you for your talk. What is your view about the adequacy of the New Jersey law? Is it a legal standard you would like to see adopted broadly?
No, quite frankly. I think that there are aspects, I mean, it's the same thing that we talk about in the context of child welfare and neglect laws, right? Where you have carve outs for religious treatment, and that become very complicated in a whole host of different ways. So, I'm not necessarily an advocate for having a New Jersey law across the country. I think what's actually more important than that is doing a better job of how we train our healthcare providers, right? I think it's really powerful that one of the things that Jahai's mom said, and I understand that this was mentioned yesterday as well, was if her interactions with the healthcare team had been different, there might have been a very different outcome in that case. And I think that that's something that we should all sort of let settle on us a little bit. And as a torts professor, I can say, one of the things that we know is that an apology is a wonderful way to avoid a medical malpractice suit, right? When people want to be seen, people want to be treated with respect and with dignity, and particularly in a set of circumstances where your otherwise healthy child, right, mostly healthy child, dies in a hospital from having her tonsils removed after your family has been ignored time and time again in raising concerns. That really speaks to not a legal problem, right? That speaks to a problem that is about training. It speaks to a problem that is about how we discipline people, and it speaks to a problem about how race in particular functions in our healthcare system. And you're not going to fix that with changing the laws across the state.
Absolutely. I also note that my recollection, and Thad will know much better than I do, but my recollection is that most of the cases that have been pursued all the way to the end and have come out in favor of the patient in futility challenges have involved outrageous behavior. Yeah. So,
Can I
all
make a
right.
quick?
Hmm? Last comment, Thad, because then we do have to take a break.
Okay. Just on the New Jersey thing, the one thing I'm concerned about, and I just think of CHOP in Philadelphia, in the summer 2018, he had 2 brain dead boys at the same exact time, right? And I'm concerned about it. So I guess I'm agreeing with Kimberly, right? Is that I'm concerned from a distributive justice standpoint, right? If Pennsylvania had the same rule as New Jersey, then CHOP would have to keep those boys. And as Bob True told us, right, pediatric ICUs are almost always full all the time, which that's 2 beds being used up for dead patients, which are beds that can't, there's a lot of opportunity that's going to be lost for other patients who won't have the capacity to benefit from the PICU at CHOP. So I'm concerned about, as Kim, about expanding that New Jersey rule.
Yeah. All right, well, with that, I believe, Christos, it may be time for a break. Is that accurate?
Yes, let's do it, and let's reconvene in 10 minutes.
All right. See you
Thank you all.
then. Thank you, everybody.
Thank you.
Welcome back, everyone. I am happy to say that we will be continuing the legal discussion, the legal, social, ethical discussion, legal constructs and complications of the conference. And at this time, I'd like to invite Professor Sid Johnson to present. Sid is an associate professor at the Center for Bioethics and Humanities at Upstate Medical University in Syracuse, New York. And take it away, Sid. Thank you.
Thank you. Let me get my slides up. Okay. I'm just going to go with it because I can't actually tell if you can see my slides. So tell me if you can't.
It looks good, Sid.
Thank you. So before we knew what brains are or what they did, humans knew death. And long before the UDDA and the ad hoc committee of the Harvard Medical School, people died. We've always died. But neurological death is very much not how death was traditionally viewed. And perhaps we want to say that those other views were pre-scientific or unscientific, but in fact, some of those pre-scientific notions were not wrong, and not wrong according to modern science. The body in rigor mortis is without question dead, and scientifically confirmably dead, and so is the decaying body. So the body with prolonged cessation of cardiac and respiratory activity is dead. And this is almost universally agreed upon across cultures and across religious and spiritual traditions. But a body with a severely damaged brain can continue to live given medical support. So the question that prompted the reinvention of death was, is that the life of a person? So I plan to argue that the death of the person is implicit in the determination and declaration of death by neurological criteria. And we've talked about this some in the yesterday as well. The very point of having a law defining brain death is that the body remains alive and thus doesn't satisfy the traditional understanding of death as occurring when the heart and the brain, the heart and the breath stop. So in the US, we have the UDDA, some variation of which has been adopted by all 50 states, which says the individual who sustained either irreversible cessation of circulatory and respiratory functions or irreversible cessation of all functions of the entire brain, including the brainstem, is dead. And there are two problems with this. The first is that they're not equivalent standards, and that's going to be mostly what I'll talk about today. They don't say or mean the same thing, because in brain death, the heart beats and circulatory functions continue, and respiratory functions can continue with medical assistance. The second problem is that the current accepted medical standards don't satisfy the statutory definition of whole brain death, as has been discussed extensively. So let's go back to the beginning and the initial claim that the two ways of being dead were equivalent. The ad hoc committee of the Harvard Medical School in 1968 claimed that our ancient understanding of death was always the understanding that the death of the brain was what counted as death. And they arrived at this conclusion by pointing out that the brain dies when the heart and respiration stop. And the committee wanted us to recognize that the semblance of life achieved through modern medicine is an illusion, that we mistake signs of life for life itself. I would actually argue they make the same mistake. They mistake signs of death for death itself. They also conclude that the permanently non-functioning brain is for all practical purposes dead. So this much is factually true. The brain will die if circulatory and respiratory function ceases. And this much is not true. Our ancient and even our recent ancestors understood death to be the death of the brain. Our understanding of death preceded our knowledge of the brain and its functions, and certainly our understanding of the role of the brainstem in controlling respiration. And the traditional and common sense and scientific understanding are all in agreement that death occurs after cardiac and respiratory functions cease. And people commonly refer to this as death, even when it is only temporary cessation, a figurative death as a medically reversible phenomenon. So it's also true that modern resuscitative and supportive medical measures can restore life according to common understandings of death. The other claim, that the permanently non-functioning brain is for all practical purposes dead, is an unproven assumption that very much depends on how we define death and whether for all practical purposes death is actually death. So it doesn't follow necessarily that when the patient's brain is permanently non-functioning, the patient is dead. The President's Commission in 1981 said, even if life continues in individual cells or organs, life of the organism as a whole requires complex integration, and without the latter, a person cannot properly be regarded as alive. Now, what did they mean by person? In fact, they went out of their way to reject the possibility of defining the essence of persons and personhood, noting the lack of agreement among philosophers, physicians, and the general public. And I'm just going to flag that point for now because I'll circle back to it later. The UK Royal Colleges of Medicine Code of Practice on Brainstem Death doesn't try to define biological death and rather defines the death of the person. And this avoids the necessity of claiming equivalence between brain death and cardiopulmonary death as it's traditionally understood. They are redefining death. And they say death entails the irreversible loss of those essential characteristics which are necessary to the existence of a living human person. So they are going there where the President's Commission feared to tread. And thus, they say, the definition of death should be regarded as the irreversible loss of the capacity for consciousness combined with the irreversible loss of the capacity to breathe. I'm going to say that that's a non sequitur, mostly because the capacity to breathe is not anyone else's idea of an essential characteristic of a person. There are lots of people who cannot breathe without a ventilator, and they are uncontroversially living and persons. There are a few religious traditions where the cessation of breathing signals death. In some interpretations of the Talmud, the last breath accompanies the departure of the soul. In Tibetan Buddhism, the cessation of breathing precedes actual death when consciousness leaves the body by several days. So even in those traditional views, the cessation of the breath isn't death itself, it signals death. The Royal Colleges of Medicine are claiming that there are two capacities, though, that are essential and necessary characteristics of a living human person. And both of those capacities are lost, as it happens, when there's damage to the brain stem, specifically damage to the reticular formation. And the relevant parts of living human person are obviously living and person, since membership in the human species is presumably resistant to damage to the reticular formation. So this is explicitly a definition of the death of the person, for which the anatomical proxy is irreversible damage to the reticular formation. It's implicit in the way that we've handled it in the US. So to its credit, the UK definition is very clear about what is to be medically diagnosed. It avoids that problem of accepted medical criteria not being consistent with the law. It doesn't claim biological equivalence between brainstem death and cardiopulmonary death, and it's clear about the conception of death as the death of a person. Although this is a controversial definition of death, it is a definition that is accepted by many people and clinicians who would apply it to themselves. And it aligns with a belief, which is also controversial and also acceptable to many people, that the permanent loss of consciousness is analogous to the loss of personhood. This has been a persistent theme in bioethics and medical discourses, especially around discussions of disorders of consciousness and the vegetative state unresponsive wakefulness syndrome. We should be careful, however, about what we actually mean when we say that loss of consciousness is analogous to the death of personhood. Some people mean literally dead, and some mean as good as dead, and some mean it in a prescriptive way, that unconscious individuals should be treated as if they are dead, which is to say not medically treated at all. Here's just a couple of examples of where unconsciousness is equated with the death of the person. So Joseph Fletcher, who was a theologian and bioethicist back in the early days of bioethics, says the vegetable patient, no matter how many spontaneous vital functions may be continuing, is dead, a non-person. Jeff McMahon, a philosopher, when those parts of the brain which consciousness and mental activity are realized are destroyed or rendered irreversibly non-functional, the mind ceases to exist. That is, the person dies. And this last quote is actually from an ethics consult that I did at the hospital where I work. A son who was describing his mother, who had just been diagnosed in a vegetative state, said, essentially, she's a cadaver with a heartbeat. But analogies, however apt they might be, are not medical, scientific, or legal facts. Unconscious individuals are not literally dead. Unconscious apneic individuals, those in coma, are not literally dead. They are not decaying corpses. They are still persons. Are they as good as dead? Should they be treated as if they are dead? Those are not medical or legal questions. Those are ethical questions. We need to know who is dead, who's actually dead, and who's not merely as good as dead. We need to know because there are traditions and practices, behaviors that happen when someone dies and when their status changes from living person to former person. And there are legal matters, reading wills, wrongful death lawsuits, and so on that happen after someone dies, after we know that they are dead. Medicine and the law and society need to know the answer to who is dead, but that doesn't make it a medical or a legal question. So the questions we have been circling around here with the definition and determination of brain death are what makes human existence valuable and what makes a human being a person? And those are metaphysical and ethical, social, cultural, and spiritual questions to which, when the entire brain or part of the brain stops functioning, is just not an answer. And that's the problem. The reason for the invention of brain death was the possibility of medical intervention that would keep the body alive. And there's no separating it from that. And so from the start, the problem was one in which the body could be kept alive when recovery of the brain and everything the brain makes possible, including consciousness, interaction, thinking, moving about in the world, were thought to be no longer possible. And so from the very beginning, the question of what makes human existence valuable was asked. And the question of what makes a human organism a person was asked. But those are not medical or legal questions. Medicine and the law are silent on what makes human existence valuable. It's not the capacity to breathe. Capacity for consciousness is certainly a component of a life with subjective value. And many people believe that without consciousness, you cannot be a valuer, and so your life cannot have value for you. And of course, that assumes that the unconscious individual's subjective values are what really count. What makes human existence valuable is a question of ethical, cultural, spiritual importance, but not a medical or legal question. And the law can tell us who is a legal citizen. It doesn't tell us who's a legal person. The US Constitution mentions persons 57 times, but it never defines it. The 14th Amendment distinguishes between persons and citizens, only defining the latter. The UDDA does not say that the brain dead are no longer persons. It describes the criteria for being declared legally dead. And a law can do that. But those criteria for being legally dead or for being medically diagnosed as brain dead are criteria for being considered as good as dead or someone who can be treated as if they are dead, a former person. That idea that persons in the metaphysical and moral sense can die while their physical bodies remain alive is something clearly that makes intuitive sense and is acceptable to many people. And many cultural and spiritual traditions contain an implicit or explicit dualism in which body and soul can part ways. But this moral or metaphysical person has shuffled off this mortal coil is not a medical diagnosis, and neither is it a matter for the law. And the most plausible justification for having a concept of brain death is that significant and devastating brain injuries resulting in the irreversible loss of consciousness result in the death of the moral person. But that's not a biological or medical or legal fact. Biology, medicine, and the law don't tell us what moral persons are. So the ethical implications of a legal declaration of the point at which a human being ceases to be a person with rights and responsibilities are many and significant. Laws have coercive force, and forcing a definition of personhood that is incompatible with someone's moral, philosophical, social, cultural, and spiritual beliefs is coercive in a way that can amount to persecution or legally sanctioned medical neglect. When Jahai McMath was declared legally dead, the hospital was no longer obligated to provide any medical treatment under California law except the court-ordered ventilation. And she was not fed or medicated for the next month while the case was litigated. And when the hospital released her to her family, they sent her to the morgue, still on a vent. Legal brain death has been a locus of controversy and mistrust because of its implications for the persons declared dead. And it is not surprising that brain death is contested when it is viewed as a way of determining what is only implicit in the law, the death of a person, the transition from being a person with rights who matters morally to a non-person who no longer has rights. It is not surprising that it is contested because the law and other human institutions have historically and frequently been morally wrong in their recognition of who is and who is not a person. The legal declaration means someone is no longer a person with a right to treatment. It means their surrogates no longer have the right to make decisions on their behalf or say what happens to them. Surrogates like Jahai McMath's parents, Aiden Hailu's father, Israel Stinson's parents. And in some of the most contentious cases, it means that organs are procured from those individuals without the consent of their families, which is what happened to Elijah Smith. So the most extreme implication of this is one that ironically circles us back to one of the motives for inventing brain death, which was avoiding medical homicide. Because we have families that believe that their loved ones were killed by an involuntary withdrawal of life-sustaining treatment or the removal of their organs. Elijah Smith's parents believe that he was killed when his organs were taken from him. The issue we've been evading and the bush that we have been beating around for decades now is this: we are not merely harmonizing modern medicine and biological facts. We are deciding what makes human life valuable and whose lives are valuable and worth continuing, and imposing a particular moral viewpoint that is at odds with what many people from many cultural, social, and spiritual traditions believe. In the last 50 years, we have often considered these questions in both medicine and the law, and in both domains have been permissive regarding the authority of patient surrogates to decide when an individual's life no longer aligns with their beliefs about what a good life is and what kind of life is valuable and what is in their interests. But the UDDA and other statutes and the code of practice of the UK Royal Colleges of Medicine regarding who is dead negate that permissiveness. They're prescriptive and have often been used coercively to impose a moral worldview about which lives are valuable. So this quote is from the President's Commission of 1981, and they were here arguing against adopting a standard of higher brain death, the explicit loss of consciousness and cognition. So on a matter so fundamental to a society's sense of itself, touching deeply held personal and religious beliefs, and so final for the individuals involved, one would desire much greater consensus than now exists before taking the major step of radically revising the concept of death. But they did it anyway with the concept of whole brain death. The sentiment and the moral and social political commitment are right. In a pluralistic, multicultural, democratic society, a pluralistic consensus and not legal or medical cultural imperialism is a goal worth pursuing. So the UDDA says an individual is dead if they have sustained irreversible cessation of circulatory respiratory functions or irreversible cessation of all functions of the entire brain. And we can slot in whatever variation on brain death we arrive at, but we should take the or more seriously. Circulatory respiratory death is nearly universally accepted. It is scientifically valid. It is reasonable. and allowing individuals and their surrogates to choose the death that aligns with their beliefs and their worldview also aligns with a core value in medical ethics. It respects patient and surrogate autonomy, and it respects persons. Thank you.
Thank you. Sid,
I'm gonna try to stop sharing there.
got it?
Did I stop?
Yes,
No.
Sid, you're
Oh.
you're done.
Okay, thank you.
Oh, yes. I have a delay on my screen here, apparently. Quick reminder to the audience. We would love audience input and questions, and we look forward to that. You cannot participate out loud. If you raise your hand, unfortunately, we won't be able to hear you if you are called on. So please type a question if you have it into the Q&A chat type box, and we will address it in some way as long as we have space and time. And next, right, following up on the look at ethical implications of brain death as a legal and social construct, we're going to hear from Shahnaz on what is required to publicly justify the law on death. He is a senior research scholar at the Kennedy Institute of Ethics and an assistant professor of philosophy at Georgetown University. Welcome, Sean.
Thank you. And thanks to the organizers for organizing this great conference and to everyone who's spoken so far. I hope to be able to make some references to what people have said as I go, because I think there's a lot to build on there. So I am, as was just said, a philosopher, and you might wonder why you're getting a philosopher again, right? We had philosophers yesterday when we talked about the ontology of death. So I'm a different kind of philosopher, I think, or at least we'll be speaking as a different kind of philosopher than Professor Liza and Professors DeGrazia. I'm a political philosopher by trade. And in fact, I'm going to be making arguments which go in some ways at cross purposes to the approach that Professors Liza and Professor DeGrazia were taking, and argue that we should define death in a way that avoids metaphysics as much as possible, right? That we should have a starting point for talking about death, which doesn't lead us directly into matters of controversial metaphysics. I'll be drawing on a tradition in political philosophy that goes back to John Rawls to argue for that point. Sorry, let me start my timer so I don't go way over here. Okay, so all right. So first, some acknowledgements. So a lot of this work was supported by a fellowship from the Greenwald Foundation, for which I'm very grateful. More personally, I'm very grateful to my late lamented colleague, Bob Veach, for advice in this paper and generally for mentorship. I had the privilege of sharing a hallway with him for several years until this past year. And as you'll see, the view that I'll develop really builds on his view, although as it happens, I came to some aspects of it independently. Really converges with what with how Bob thought we should define death in a variety of ways, but starts from a very different starting point. So I really think of this project as, in a way, an homage to Bob. Also, I'll briefly mention, since she's here, that everything I know about PowerPoints I learned from Professor Seema Shah when we were working together at the National Institutes of Health. She did a great speaker training, but I can't blame her for my bad PowerPoint any more than I'll be able to blame Bob Veach for my bad any bad philosophy. Okay, so to the substance. Okay, so we've heard a lot of talk about different conceptions of death, right? So I want to draw a distinction about different ways that we can talk about death, right? So this should be relatively familiar to people. There's many debates about the conception of death. Those are about what death is as a thing in the world, right? Whether it's the irreversible loss of brain function, that's the cessation of circulation, or potentially the loss of higher brain function, right? That's about what death is as a thing in the world. And then yesterday we heard a lot about debates about standards for death, right? So once you've decided what death is in the world, say you've decided that it's the loss of all brain function, you can have all kinds of arguments about how you would measure that, right? So I'm not going to be talking about standards at all, and only a little about conceptions. I'm going to be talking primarily about what I'll call concepts of death. So if a conception of death is an answer to a question, a concept of death is an account of what question you're asking, right? So what are we saying when we say that death is the loss of all brain function, or that death is the loss of circulatory and respiratory function, right? So this is a project in the first instance about almost like the dictionary or lexical meaning of death. Now, I'll assume that there are a variety of different meanings, and so my job won't be the lexicographer's job of going out and trying to capture those in one definition. Rather, I'm going to be making an argument that for certain purposes, we should fix on a certain definition or meaning of death, right? So I'll be making an argument about what question we should be asking when we ask in law and policy contexts whether someone has died. So first, some points about the question, or at least one of the main questions, one of the main ways this question has been framed in our public justification of laws and policies like the UDDA. If you look at that justification, first the President's Commission's report, and especially then the Council report, much of the debate has seemed to be about the following question: when does an organism cease to exist? When does a human organism cease to exist? Right. So in the Council report, you see different views on that. Yesterday, we had a whole session arguing for two different views on that, one brain-based and one non-brain-based. So the presupposition of all these debates seems to me to be, and we can talk more in Q&A about what, whether and what way this is a presupposition. But the presupposition here seems to be more or less the view that David DeGrazia defended yesterday, the kind of ontological and related definitional view of death that David DeGrazia defended, on which what it is for a human being to die is to cease to exist. How do we know when a human being has ceased to exist? We know that a human being is an animal, and then we ask when an animal of that kind ceases to exist, right? And then we go on and have a debate about whether that's determined by a fact about the loss of brain function, or a fact about the loss of a broader set of integrating functions which don't require brain function. So my concern about this, the way that this has been, if not always, then often, at least often framed in the public justification, is just that this presupposition is an object of reasonable disagreement. So it's both an object of reasonable disagreement that we are animals, and then to interpret what it means for us to be an animal is a matter that inevitably leads to deep and intractable philosophical disagreements, right? So even getting into religious disagreements, many secular philosophers, of course, deny that we're animals. They think that we're minds or persons, right? And then, of course, as we saw, it's deeply controversial what an animal is. For other purposes, I've been reading in the philosophy of biology literature and writing a bit about that, and it's a profoundly controversial matter. What distinguishes one animal from another, the conditions under which an animal begins or ceases to exist. These are deep and possibly intractable disputes. It's not just philosophers that disagree with the idea that we're animals and that our death is the death of an animal. Many religious perspectives would hold, and these are serious views that people in our society hold. Many religious perspectives would hold that we're not animals. They offer various alternatives besides the kind of Lockean philosophical personhood view. So on one view, we're immaterial souls. That's been defended by in various Christian traditions. Not all, of course. Some Christians think that we're animals, and some think that we're persons, but some think that we're immaterial souls. And that should say nothing at all. Of course, there's a major world religious tradition, which is famously, that is Buddhism, which is famously associated with the idea that there's some important sense in which we don't really exist, right? So my question is this: how are you going to justify the law on death if you're saying, look, here's why you've died, right? Here's why your loved one has died. They're an animal. You are too. And an animal ceases to exist when, fill in your favorite conception of death, right? Brain death or certain cardiorespiratory death, right? And so they're dead, right? There's an obvious problem with that justificatory argument when offered to someone who, as a kind of interpersonal political justification, when offered to someone who, as a result of deep and sincere philosophical or religious belief, doesn't accept that they or their loved one are animals. souls. They think that they're souls, or they think that they actually, in some deep sense, don't exist, or that they're persons. The justification for the law that the Commission and Council report suggest is a justification that has presuppositions that people who we ought to justify ourselves to, right? People who are perfectly willing to get along with us in our society and perfectly capable of it, couldn't accept, given their deeply held views about what persons are, right? What we are, right? What we okay, so that's a kind of intuitive rationale for the idea that we should be concerned about ways of talking about death, which inevitably mire us, inevitably presuppose claims about what sorts of things we human beings literally metaphysically are, right? So I'm inspired here by a tradition that goes back to my former teacher, Charles Larmore, and more famously, John Rawls, on how we should justify things like our fundamental norms regarding, when we'll stop giving each other medical treatments, right? So Rawls famously defends what he calls the liberal principle of legitimacy, on which our exercise of political power is fully proper only when it's exercised in accordance with the Constitution, the essentials of which all citizens, as free and equal, may reasonably be expected to endorse in the light of principles and ideals acceptable to their common reason, right? So I think that a justification of a death statute, which makes controversial metaphysical presuppositions about what kinds of things beings like you and I are, right, fails this test, right? We just can't ask people to accept that justification because it contradicts something which they're entitled to believe, and as Rawls and others have argued, not just entitled to believe, they're entitled to have a justification for important laws and policies, which doesn't contradict that belief of theirs, that metaphysical belief of theirs. And so I think the problem here, my diagnosis, the problem here is that we've implicitly defined death. The question that we're asking when we've asked whether someone has died, we've defined it in a way, right? Defined it in terms of the end of the career of the organism, which inevitably, or even the same problem would arise if we define it as the end of the career of the person, right? The ontological metaphysical stopping point for the sorts of things that beings like you and I are. That way of framing the question, that way of asking when someone has died, right? That thing to mean by death when we ask that question, when has someone died, that inevitably leads to metaphysical controversy, right? So is there a way of avoiding that? Well, I'm going to argue that there is. So here, as I said earlier, so just check my time. As I said earlier, I'm converging with a view that has been defended by Bob Beach. Before I get to that, though, let me say why I think that a different response, right? So what I'm eventually going to do is to defend a different view of the concept of death, right? A different question that we should be asking and answering in these debates about when someone, what standard we should use to determine when someone has died. But a different, though closely related approach is to say, look, people disagree about what death means. Just let people mean what they want to mean by it, right? Let people agree to disagree, not just in the Ross and Veach sense of letting people pick which standard will be operative in their case, but let people pick what language and concepts they want to use, right? So this is something that Kristen Zeiler has proposed. So I just want to briefly say why I think that we can't do that. Why we do need, for certain purposes, a common kind of lexical meaning or concept of death that we can all have debates about, and then hopefully conclude those debates, or at least feel for ourselves like we've offered in those debates sufficient reasons that people from different perspectives ought to accept without having to give up their underlying metaphysical and religious perspective to accept it, right? So I think we need a common concept for a few reasons. One, I believe Michael Nair Collins is here. So I think that there can be a kind of there is and can be a kind of problematic sort of cacophony of different voices in significant interpersonal, justificatory, and ethical contexts if people in those contexts mean different things by death, right? So what Nair Collins has argued is that there are potentially in our current system serious problems with the validity of consent to various things which are putatively consented to conditional on death, like organ extraction, right? So if the family says you can take her organs after she dies, and if they think death means one thing and the doctor thinks it means another thing, it's not clear that they've consented to one and the same thing that the doctor then does, right? So there can be really serious ethical problems that arise when there's polysemy or sort of interpersonal ambiguity in the meaning of death. I also think, and this is a point that Beach and Ross have also made, that there will be various contexts in which we're going to need a default standard, right? So sometimes we don't know how someone would define the word death for themselves, or what particular standard of death they'd like us to use, brain-based or respiratory or higher brain. And so we're going to need to have a law which says when you don't know what death is, what someone thinks about death, their death is such and such, right? And I'm actually here not going to defend a view on that. Beach and Ross's view, which I think is reasonable but defend, is that should be whole brain death. But my point is just that we need something for the law to mean by the word death in the when it adduces those general standards. So even if we didn't mean something for the law to mean by death when we're talking about individual clinical decisions about individuals, because we can use their own meaning of death. I'm not sure that's true, but even if that were true, we need a common definition to use in laws that apply to unknown, or in the third case, kind of essentially anonymous people who are anonymous decedents. Okay, so what should this common concept of death be, right? So I've argued that it had better not appeal to metaphysical concepts of a kind that inevitably lead to reasonable metaphysical disagreement, right? So we shouldn't define death in terms of the end of the existence of beings like you and I, whether we construe that, as the reports seem to, as the end of the existence of a human animal, or if we were to decide to switch to construing it as the end of the existence of a person, or I suppose that David deGrasse's third option, Jeff McMahon, was to construe it as the end of an embodied mind. All of those things inevitably mirrors in metaphysics. What we really need is, we do need something to collectively mean by this, and we need that because we need to justify to one another certain death behaviors, right? So this naturally leads us in the Beachian direction of defining death directly in terms of those behaviors, right? In terms of the moral implications that we want to draw when we have decided that someone has died, right? So Beach provocatively says in the title of one of his articles that the dead donor rule is, as it were, true by definition, right? And I'm going to ultimately, I think, come close to agreeing with that. Where I disagree with Beach is that I don't think that this common concept of death, the one that we all have to agree on, I don't think it has to be good enough for purposes of justifying all of these death behaviors. And thus, I don't think we have to go with Beach to this kind of deep idea of full moral status, right? Beach is saying that death is the kind of bodily change that warrants a loss of full human moral status. I think we should try and avoid that too. That's morally too rich, given that there's going to be moral disagreement about what grounds full moral status. But I think there's at least a prospect that we can avoid these deeper and broader moral issues by restricting the range of death behaviors that we think are definition of death, that we incorporate into this kind of moralized definition of death. So we don't need to justify to one another as fellow citizens claims about when the mourning process should start, when wills should be read, when burial rituals should happen, right? So some of these are things that don't need to be publicly justified because people can just differ on them, and that's fine, right? 3 and 5 would probably fit that. Others don't require a public standard because they can be handled contractually, right? So the life insurance and health insurance contracts can have a definition of death incorporated. They might want to incorporate just use a public definition of death instead of stipulating one, but they don't have to, right? So I would propose that we define, modifying Beach, that we define death as that state which justifies the death behaviors which need to be publicly justified, right? Which we have to justify to one another. So let me make that a bit more rigorous. So here's my big proposal, right? This is the philosopher's claim with variables and clauses and the whole full deal, right? So so this is what I'm here, I suppose, to defend. So please make objection. So my proposal is that to die, in the sense of death that ought to be used in legal and political contexts, is to reach that level of functional decline, call it F sub D, such that as soon as someone's body has reached that level, it is no infringement of their past or present moral rights, either one, to withhold interventions that would prevent further functional decline in their body, or two, to perform interventions which would produce further functional decline and or preclude functional recovery. I'm thinking here, maybe right? So basically the idea here is to just define death, to use the word to mean that state of the body which justifies the withdrawal, permits the withdrawal of life support and the extraction of organs. That's the kind of simple version, right? My idea is to reduce the kind of content of a moralized definition of death to just the nub of what we really have to agree about, right? In hopes that if this is what we mean by death, when we try and figure out whether someone actually has died according to this definition, we won't have to go too deep into controversial metaphysics or even the most controversial precinct of morality. So let me say a little bit more before I close about why I think we can hope that we don't have to go into those deeper precincts, right? Because it's still possible for someone to say now, look, like to decide whether somebody has these rights, you're going to need to do the very kinds of metaphysics that we were doing yesterday, or the very kinds of debates in the philosophy of biology that we were doing yesterday, right? And I can't refute that here because I'm just trying to propose a kind of new or adjusted starting point rather than having finished the project that starting point would start us on. But let me rebut some reasons to think that kind of at the outset it would be impossible to defend a view about when this rights transformation happens, right? Which wasn't which doesn't immediately lead to metaphysical problems, right? So I can, short in time, I'll skip the first one, but one which I think would be well worth addressing would be a concern that look, how can you decide whether somebody continues to have rights at a time unless you've continued to decide whether they've existed at a time, right? Like you, Sean, have said, basically somebody is dead when their rights in their body go away, basically, or at least when they radically transform from the kinds of rights we have in a living body to the kinds of maybe lingering rights we have in a corpse. But notice that actually I don't mean to defend a living person as a rights holder, right? So I don't mean to say that you have to exist at a time. I don't mean to contradict the idea that you have to exist at a time to have rights at that time, right? So it's a little bit subtle. I'm happy to explain it more in Q&A, but just to give a brief motivation for this, I claim that you're alive as long as your distinctively bodily rights can be infringed. This doesn't entail that you that you exist at that time, so you can have all kinds of different metaphysical views about when you exist and still think that your body rights can be infringed, even at times at which you don't exist, right? So just to briefly motivate this, imagine the following example. The idea that is to motivate the idea that your rights can be infringed after you cease to exist. Consider the following example. I'm a lieutenant in Vietnam. Tragically, many lieutenants in Vietnam died very quickly. Tragically, imagine that I'm one of those, but that before I get blown to smithereens, I give an order to my platoon to charge up the hill, right? I think they're still obligated to charge up the hill, even after I've been blown to smithereens, right? And therefore, virtually no longer exist, right? I think we could describe that as a case where my right to command a platoon would be infringed by their deciding not to charge up the hill, right? And so that's just to rebut like a kind of quick reason to think that even my rights-based moralized definition of death is immediately going to run right into the same metaphysic I want to avoid. Perhaps a harder set of issues is concerns whether we can avoid profound moral controversy. So I certainly don't want to suggest that we can avoid moral controversy per se, right? We're going to have a moral and political debate about what changes in the body warrant the withdrawal of these rights. But my proposal is to try and make our moral disagreements as non-profound as possible, right? To try to avoid profundity, right? So this is the lesson of the politically liberal tradition, is in a pluralistic society where people disagree about the profoundest stuff, try and figure out how to justify things to one another non-profoundly before you go to profundity, right? Try not to get into the deeper debate if you can, right? Try not to have to decide which religion is correct before you decide what speech should be allowed, right? Try to avoid that kind of depth and profundity. Someone might think that you sort of can't possibly do that because to know when people have rights, when they have claims to continued life support or claims against organ extraction, even if you don't necessarily have to know when they come into existence or go out of it, you still have to know something that's very morally deep, right? So this is getting it back a bit towards Beach's view, that you have to know what kind of ultimately matters for the human being. And so on this basis, the philosopher Jeremy Williams has argued that the whole issue of death is a major sticking point for the politically liberal tradition, because they'll never be able to describe the conditions under which people continue to exist or not exist for these kinds of political rights-involving purposes without going deep on what ultimately matters in human life. So I won't be able to answer this critique here, partly because I'm running out of time, partly because it gets at this kind of deeper question, a deeper and broader question, for which you could stay tuned for my hopefully manuscripts, of what is it that gives us claims on our bodies with respect to other people, right? What is it in the first place? Why in the first place should you give me life support if I need it? Why in the first place should you not take my organs while I'm alive, right? I think we're actually sort of philosophically and as a society only at a very early stage of understanding that question. And I suppose my kind of philosopher's proposal, the thing that might make me stick out a little bit and like a sore thumb in this sequence of more practical proposals, is that I'm not sure that we can publicly justify the law on death until we have a much better public understanding of the basis of our rights in our bodies. Because I think, as I've argued, that we need to define death roughly in terms of our rights in our bodies, and therefore that we need to understand those rights better before we can know exactly where death falls. Okay, so I've defended a certain view about the concept or definition of death here, view that death should be defined as that degree of functional dissipation that grounds a public justification of death-related rights transformations. I haven't defended any particular view about conceptions or standards for death, but I can say abstractly this, that what death is going to depend on what it is about the functioning of our bodies that gives our institutions reasons to protect us with both positive rights to things like life support and negative rights against things like organ extraction. So that's the place to look. So when we look there, I'm not sure exactly what we'll find, but I just want to close by suggesting a couple of potentially sort of substantive implications about the conception of death that I think this debate using this concept would lead to. So I think I'll start at the bottom, that this kind of view, the idea that we're alive as long as we have certain kinds of rights in our bodies, roughly, right? That this is going to support at least some degree of pluralism in the definition of death, not in the definition of death, but in the standard of death that will actually apply to people in the clinic. Now, this is going to be perhaps not unlimited, right? Because as I believe Professor Pope pointed out at one point, there are questions of resource scarcity, right? And Dr. Krug also mentioned this, right? So there's going to be a question about, there's a sort of prima facie reason to think that whether somebody has a right to continued life support is going to depend on what they think about the conditions of their own existence. But of course, it's also going to depend on the effect that that's going to have on other people, right? Because the kinds of rights that's going to make sense to grant everybody are going to depend on considerations of, I would argue, distributive justice. One final point, looking ahead to our discussion this afternoon, it seems to me that this rights-based view might also support a better account of what's going on in cases that have come to be called donation of cardiac death, right? So, the thought here would be, I'm saying that you die when you no longer have a right against organ extraction, The way this is now discussed involves this kind of weird fudging of saying that there's something called moral or legal irreversibility. Doesn't seem to me to be really a kind of irreversibility. That seems like a kind of legal fiction or fudge. The view that I'm defending, the conceptual definition that I'd like to defend about death, would allow us to say that could potentially allow us to say that people are can be dead at least in certain circumstances just by their decision to be dead. Right now, that's a question. When that would be, I couldn't do it right now by saying, "Look, I'm dead," because my rights to my body are at this point inalienable. Right? If they're alienable, if they're permanently alienable, it's as a moral matter, it's likely to be only at the very, very end of life. Right? But if that's true, then there would be at least a possibility of saying that people who have non-reversibly ceased to function, if they had previously said, when I stop functioning, but before it becomes irreversible, I don't need my body anymore at that point, then it may be morally plausible to say that they've permanently alienated their body rights at that point, and therefore that they are in fact dead on the account of death that I've offered. Which I know I should end, I'll say in closing, to connect this to particularly Jaw's talk. This is, I think, to defend a kind of status view, right? The idea that we should define death as a legal status as opposed to a fiction, a status that involves a certain kind of transformation in life. Great, thanks for listening, and I appreciate your patience. I'm sorry to go over a little bit.
Thank you very much. Fascinating discussion. I'll look forward to more in the Q&A about that. Right now, however, we will be joined by Assistant Professor Erin Paquette at the Department and Assistant Professor of Pediatrics, Critical Care at Northwestern University Feinberg School of Medicine. And Professor Paquette will be talking about how do we engage the public on this subject. Thank you.
Thank you, and thank you to the Neubauer Collegium, and as well as Jessica, Christos, and Lainey for your leadership in putting this symposium together and for the invitation to participate in it. Okay. In terms of disclosures, I am a pediatric intensivist. I do a significant amount of work in equity and diversity, which certainly informs some of my viewpoints today. I've disclosed my funding, but nothing related to the work that I'm going to talk about today. So I want to start and end today with words of families who've lived the experience of brain death determination, recognizing that I can't know their experience, but I can hear and share their words as a reflection of theirs. Professor Mutcherson, who I also want to thank for her powerful words earlier today, really set the foundational backdrop for a lot of what I'm going to talk about, and in particular outlined this comment made by Jahai McMath's mother, which is that no one was listening to us, and I can't prove it, but I really feel in my heart, if Jahai were a little white girl, I feel we would have gotten a little more help and attention. So when we think about bringing voices of the public into discourse about brain death, I think it's important to start with thinking about what is public engagement. And to understand this, I would consider definitions of engagement in community engaged research, where I think this has been more formally described. The CDC talks about working collaboratively with and through groups of people affiliated by special interest or similar situations. The Patient-Centered Outcomes Research Institute talks about meaningful involvement of patients, caregivers, other stakeholders throughout the process. I think what is key to both of these definitions is the theme of collaboration and meaningful involvement throughout all steps of a process. I think what's also important is the recognition that there are many potential publics. Individuals belong to many different types of groups, and publics, these might be structured, such as religion, or unstructured groups, such as those who've shared a similar experience, like a loved one in the hospital. In a subject that has legal and social implications and political implications, it's important to represent the diversity of different publics when we think about public engagement. And as I'll come to later, principles of justice, I think, also support inclusive engagement. So if we accept that brain death is a social and legal construct, authentic public engagement, does not it does not mean looking at how we convince the public or educate the public to accept a conception of brain death that was not informed by representative public views, but rather it is to think about what is the process to actually engage, to get the public involved in, and to try to understand the process and inform it. So we can start with, what does the public understand? Perhaps the most comprehensive review of public understanding, public perceptions was done by Professor Shaw and colleagues in 2015, in which they conducted a narrative review, ultimately of 43 studies that concerned public attitudes towards brain death. This study included 27 primary studies that interrogated family members of brain dead patients and 16 studies that interrogated members of the general public. The study, the narrative review study, demonstrated 3 areas of public confusion among both of these groups. Those included confusion about the understanding of biologic implications of death by neurologic criteria, with things such as beliefs that individuals can hear, think, feel, and have awareness of their surroundings when brain dead. Misunderstandings about the legal status of brain death, in which a significant percentage found the legal definition of brain death false, who believe that the medical declaration of brain death could still mean a person is legally alive, and that oftentimes couldn't identify a connection between brain death and legal death. And there was misunderstanding about the notions or the ideas of brain death and organ procurement as separate concepts, with a significant percentage believing that the ventilator is removed prior to organ donation, suggesting that a person is a donor under death by neurologic criteria still only after their heart stops beating, which is not true. The paper concludes that empirical research is needed that begins with participants who have an accurate understanding about the facts of brain death, ideally via a survey that includes a robust educational component. However, in the absence of a clear mechanism for such education, how can we turn to existing other sources to validate or challenge what has been reported previously? And I would suggest that there are a number of existing sources that we can turn to inform our views of what the public understands. The first is to look at community engaged ethics groups. So here I've shared some descriptive criteria of 2 community ethics groups, which have considered the issues surrounding brain death. You can see that both groups are similarly constituted. They represent diverse occupations. They both reflect training in ethics and respond to requests for consultation. Before deliberating on questions related to brain death, members of both of these committees were informed by a combination of academic articles, professional society statements and guidelines, videos from the 2018 Harvard Conference on Brain Death, and videos from the popular media, suggesting that the process of both committees allows for education before discussion. Within these committees, there were several concerns identified about defining and determining brain death. The first is that brain death is different from death. It just is. There's this intuitive distinction that exists. Individuals reflected on this through comments such as, the term itself is confusing. You can't be heart dead. Brain dead bodies can gestate a fetus, heal wounds, hearts can beat, but a body in the morgue can't do those things. The second concern is that there was a fluid determination of death, even among clinicians. So that many members of the committees felt that tests seemed prone to clinical subjectivity or bias, and they were hesitant to trust a process that held irreversible repercussions to the patient. There were concerns about the conflation of a declaration of brain death with preservation of organs. In particular, there was reservation about the mandated presence of representatives from organ procurement organizations. There wasn't decreased interest in donating organs, but a general agreement that authorization ought to be contingent on comfort with the medical team, or that it was contingent on comfort with the medical team, not just the representatives from the OPO. And that even with a legal fiction in place, many believing in the concept of a legal fiction to reflect brain death, that the majority in these groups found it permissible to donate organs. Finally, there were specific concerns about the apnea test, with some raising the idea that just the thought of withdrawing a ventilator as a diagnostic test was morally troublesome, and it had the potential risk for destabilizing a fragile patient, which couldn't be justified as in the best interest of the patient. I think one of the most reflective comments from these groups was this idea that change has to come. I expect that the definition of death is on the cusp of becoming a moving target, that is a subject of ongoing dialogue as advances in medicine and biotechnology will continue to open new gray areas between what we have traditionally understood to be life and death. In addition to these concerns about the determination of death, there was also concern about or discussion around whether there ought to be consent or opting out, and communication around the determination of death. Opting out and consent were not supported by the one committee that directly considered these, but it was felt that safeguards ought to be in place, including ability to appeal judgments seeking retesting, that there ought to be accommodation for limited extension of time on life support, but not necessarily funds for long-term support, that definitions and determination of death ought to respect the metaphysical transition that occurs in the dying process, and that there's critical importance of communication and support for brain death with increased transparency. Individuals felt that there really ought to be practical training for skillful, competent, compassionate communication, and that it could not be expected that families could readily transition from pursuing life-sustaining treatments to conducting clinical diagnostic tests to determine death in a patient who appeared the same. There was unanimous grief expressed across the groups about racial bias in medicine, and for the potential for that to spill into how we discuss brain death and how we implement it in practice. So I bring the ideas from these community ethics groups to us to consider, both as a way to reflect perspectives within the public, but also as a way to describe a mechanism by which we can better engage the public, which is using a mechanism of public deliberation similar to what both of these committees employed. An issue is best suited for public deliberation when there are decisions pertaining to conflicting values about the public good, topics which are controversial and divisive, and hybrid topics, which I would argue brain death squarely falls within, that combines technical or expert-informed knowledge and real-world knowledge. Topics that are suitable then require a more general reflection on cultural and practical knowledge and on how particular decisions impact people's lives. In addition to community ethics forums, I think another broad source by which we can try to ascertain perspectives of the public is looking at cases of refusals. And this has come up in some of the discussion we've had in the chat and questions that have been raised before. So in the next several slides, I'm going to share some data from a study that was done to assess factors associated with refusals of the determination of brain death, and both in terms of sociodemographic characteristics as well as reasons for the refusals of brain death. This was a mixed method study that started as a large survey about provider practices. A subset of that group responded to questions if they had experienced a refusal, and then a smaller subset agreed to be interviewed about specific cases. So here I'm sharing some data about the association of practices with the experience of refusal. So experience of more than one refusal was associated with several practices. The odds to experience with the refusal was associated with a 2.9 times odds, a tendency to obtain permission to perform the evaluation for death by neurologic criteria, 3.8 times the odds of willingness to permit philosophical or religious objections to DNC, 4.5 times the odds of having a belief that parents have the right to refuse entirely the evaluation for DNC, and 3.3 times the odds of the belief that the parents have the right to refuse the apnea test. This data suggests that there's either a subset of providers already sympathetic to those who object to the determination of death by neurologic criteria, or there's something about the lived experience of a refusal case that alters perspectives of at least some providers. It challenges the belief that there's uniform or even widespread acceptance across the medical profession, despite what expert consensus might suggest. In the subset of cases in which providers experience refusals, we looked at several characteristics of families and providers. Families were largely minority, so only 46% of the group were white, non-Hispanic. The majority were religious. The majority were of lower or middle socioeconomic status. There were language barriers in 16% of the cases and trust raised as a concern in 62% of cases. Religiosity in these cases was associated with objection to brain death. Race and ethnicity was associated with needing time for others to arrive before the declaration of death. Lower SES was associated with needing more time to grieve, and lower educational status was associated with believing individuals could wake up after a diagnosis of brain death. When looking at characteristics of providers in these cases, sociodemographics were different. This group was majority white, non-Hispanic, though the majority here were also religious. Language barriers were associated with provider family ethnicity difference. Language barriers associated with objecting to death. Family provider religiosity discordance, so where the family was religious and the provider was not, or vice versa, was associated with religious objection to brain death. And family provider religiosity concordance was associated with not wanting to give up and not believing in brain death. So I think what these data suggest that there is a sociodemographic divide between families who refuse and providers who care for them, and that sociodemographic characteristics are associated both with refusal reasons and the need for time. This slide outlines in the 12 cases in which we had more discrete information what was refused. The second exam was refused in the majority of cases, which suggests to me that there may be information that a family is learning about brain death between the first and second exam that they didn't know previously that impacts their refusal of the second exam. 9 out of 12 children in these families died in the hospital. 3 were transferred home. Reasons we've heard before were cited: waiting on a miracle, religious objections, feeling that individuals had the right to refuse, and refusing the concept of brain death. And there were several strategies employed to try to resolve these cases. What these data, I think, as a whole suggests is that refusals cases can provide key perspectives that counter the view of widespread public acceptance. This is a distinct public that needs to be engaged outside of assessing general perspectives on the acceptance of brain death. Some others have raised the question of whether there are things we can learn from case law that also inform what we understand from a public perspective. Beginning to look at several of the cases in which there's been objection to brain death and request for accommodation. And I'd like to thank Professor Pope for so brilliantly collating many of these resources, that there are things that we can get out of looking at these cases, at the complaints, as well as the decisions that help us understand public perspectives. Looking at these cases, there are a number of moral or intuitive concerns, including religious objections, moral objections in clashes of definitions of death, the notion that surrogates ought to have the right to decide, that determination of death is seen sometimes as a coercive alternative to family declining requests to withdraw life-sustaining treatment, and that the physical appearance of the body and perception about its functions is powerful and meaningful. In one case, with a parent stating that the patient was responding to the parents' voices and the patient's brain was merely resting while her body healed. There are also practical and policy considerations that come out of these cases, including notions that ancillary tests are essential to definitively defining DNC, fear or loss of insurance and ability to receive appropriate care, and that in thinking about determination of death as a policy matter, the values, wishes, and beliefs of individual patients are important to consider, and that the determination of death ought to accommodate these beliefs. And finally, that doctors and hospitals may rely on legal formulations of death for defense, with statements such as, "We do not desire such an outcome, but must comply with the law." That providers making comments like this really may shelter themselves from under the law as feeling required or obligated to do what they're doing. So how do we turn from this for thinking about how to authentically engage the public? And I'm going to both provide some suggestions that grow out of considerations of how shared decision-making happens in a culturally sensitive framework, as well as matters that pertain more specifically to brain death. So the first is that I think as an academy, we need to acknowledge that there's a potentially compounding effect that undermines a public trust when processes exclude the public. So we need to have inclusive deliberation committees to avoid the perception that a non-diverse community sets the standards, advocates for codification of those viewpoints into law, and then turn to law as a defense of them. We need to use public deliberation processes like that used by community ethics committees, open meetings to the public. And I appreciate that this meeting is open to the public. And I think with the wide audience largely is engage some of the public, but I think it needs to not only be open, but with targeted invitations for attendance at a minimum and participation in an ideal state to groups within the community. We need to practice both epistemic and cultural humility and avoid homogenization. This is a notion of not thinking about ourselves as a singular community and as reflective of public values. We need to, I do stand on the side that we need to incorporate public perspectives from non-dominant views into policy. And I can address later that I don't think this threatens uniformity if it's done in a uniform process way. That we need to have transparent education with readily available policies and procedures for appeal and provide meaningful opportunity for public comment. This necessitates notice that is far reaching to the publics that we're interested in being informed by. And we have to have honest dialogue about organ donation and resource allocation. I'm not a political philosopher, and I was debating whether to include this slide at all, but I do think it's important a little bit to think about why. So why should we, what is justification for public engagement and accommodation? And I think we can turn still to principles of Rawlsian justice to justify these positions. If we think about placing ourselves in the original position, ignorant to knowing what values, goals, goods, and challenges might exist in our world, the liberty principle under this conception of justice supports policies that allow free expression of diverse viewpoints, which would support different conceptions of death, both to allow views and values that deviate from the dominant view about brain death, so accommodation, as well as views that support a legal foundation of death or legal definition of death to permit organ donation with heart-beating donors. And I think that this liberty principle also binds access to resources and goods at the point where one's expression of liberty intrudes on the freedom of others. And this gets to the question of how do we think about allocation when there are periods of scarcity? I think the notion of 2 brain dead patients in 2018 at CHOP using ventilators and beds in that unit came up earlier in today's discussion. But I think those are separate questions from what it means to be dead. Those are questions about how we choose to allocate resources, I think, which can be answered and approached to the medical community broadly, to the use of medical resources broadly that don't necessarily need to invoke a certain conception of death to appeal, and with an understanding that principles of community needs and not individual needs may need to dictate those conversations. I want to end again, just grounding us in the thought that those who go through this experience understand most what the implications of our discussions are. And this statement by a family member, I think, reflects the depth of emotion and moral value around the idea of death. We wanted him to go in peace according to our religion. They kept pressuring us to take him off life support. They kept telling us to do it. In the end, he did not die the way he wanted. He did not die honorably. Thank you, and I'll stop there.
Thank you very much. Quite a lot to think about here. It's time for some questions for the panelists. We do have some from other panelists, of course, and we have some from the audience. So first of all, I'd like to ask Seema, I believe, led us off in terms of expressing an interest, ask Sid a question.
Yes, really wonderful presentations. I wanted to ask Sid about personhood as a potential default. So Leonie Friedman Ross and Bob Beecher had this idea that you could have different conceptions of death and one default. And I'm wondering, can you imagine a process where a community, a society comes together and says, this is a reasonable default view of death that a lot of people hold, that there is this death of a person. And then there are medical criteria that we think will, in every case, without false positives or negatives to too large of an extent, try and actually carve out when a person has been lost. And then you could still allow exemptions. But I was sort of wondering how much what you were arguing about was a critique of our current system versus something that would really preclude ever moving towards a different system that relied more heavily on the death of a person as a way to determine death with allowing for reasonable alternative views.
Um, so I do think that the conception of brain death we have now is implicitly, at least, a conception of the death of a person. We just haven't said that, right? That's the quiet part. And so we could acknowledge that more explicitly in the way that the UK has done, for example. But I do think it's still necessary for us to have an exemption, as you say, because that will not be a universally accepted view of what it means for a person to be dead. I mean, as I said, we're already really permissive about people's own judgments about when a life is effectively over, when it's okay to withdraw life-sustaining treatment. Many people who die in neurointensive care die because treatment has been withdrawn. So I think we're already really permissive, and it's already the case that there are a lot of people who do think that the loss of consciousness or the loss of consciousness with very little possibility of recovering it is reason enough to accept that that person's life is over as a person. And we should continue to be permissive about that. I'm more worried about the way that the law that we currently have is not used permissively, but coercively. That it's basically a cover for saying we're not going to keep this person here anymore. The law says we can withdraw treatment, and that's what we're going to do. So I'm more concerned about that and those cases where it is incompatible with someone's beliefs that this individual is dead.
All right, thank you. I think that Sean also wanted to enter the conversation here.
Yeah, this question is also for Sid. I was curious about the conception of personhood that you're appealing to here. At one point you said that someone who was permanently unconscious might still be a living person, and I was just thinking, back to Professor DeGrazia's talk and to the kind of standard Lockean views of personhood. Where that's a little hard to make sense of, right? Because personhood is a set of capacities that someone with, a non-functioning forebrain couldn't have, right? It's involves capacities for things that require consciousness, right? And so one question is just a clarificatory question about the meaning of personhood, but there's also kind of suggestion, which goes back to some of the other things I was saying, which is that if by personhood there you meant a kind of social conception of personhood, so that the person in the bed is still a person because other people treat them as such and are like reasonable in treating them as such. Seems to me that idea of personhood would be able to capture the idea that, at least in certain circumstances, someone in a persistent vegetative state is still a living person, whereas the traditional Lockean view seems unable to.
Yeah, I mean, I could talk about this for several hours, but I won't. The view of personhood that I was sort of focused on there is the one that I think is implicit in our brain death statutes, and also in the UK very explicit declaration that this is the death of a person, right? The loss of consciousness. So, I mean, these capacities conceptions often include consciousness as sort of the linchpin of personhood. But I mean, personally, I'm a pluralist about persons and personhood. And so I think there's a lot of different ways that someone might be a person, and they're compatible with the possibility that someone who's unconscious is a person. Most of my work is on disorders of consciousness. And so I think about that question a lot, about whether, the loss of consciousness, the believed loss of consciousness, the possibly irreversible loss of consciousness, is death or means that you're no longer a person. So, as I said, I could talk about it for a long time, but I won't. We're on something else.
We actually had another question, and his name did just come up. David?
Yes, thank you, Sid, and the other panelists for terrific talks. And Sid, Seema, Sean, and I all thought about something in relation to personhood, so at least you're warmed up, I guess, on that. that topic. I would, so it's your view that our standard of whole brain death sort of, it's implicit in that is that a person goes out of existence then, and that's how we should understand our death. But that would seem to be true only if we're, at least at first glance, only if we're essentially persons. And so, and you mentioned consciousness just now in talking about Sean, presumably consciousness is not sufficient for personhood, assuming, say, goldfish are not persons.
No, I think it is sufficient, actually,
Okay.
but not necessary. Yeah.
Just any consciousness is
Sure.
sufficient for personhood in a Homo sapiens or in anybody?
As I said, I'm a pluralist. I think that there are persons who are not humans.
Yeah, I mean,
they're certainly,
as you know, I'm sympathetic to that, but it's hard to imagine that those people who formulated the laws of the whole brain standard shared that particular view. But then again, maybe you're just announcing your particular view. Does that suggest that if we're essentially persons, though, and consciousness is sufficient, maybe it's not necessary, but then it would seem to follow that a fetus developed to the point of consciousness as a person, maybe that might work fine for your overall view. Okay, well, I think I understand a little bit better how this is holding together. Are you assuming that we're essentially persons?
I'm not. I'm actually not making a metaphysical statement here. I think that we're talking about moral personhood, which might come apart from metaphysical personhood. I mean, Locke's ideas about metaphysical personhood, but it has sort of been transmogrified in the discussion about consciousness into moral personhood, right? Someone who lacks continuing consciousness, someone who lacks memory and diachronic access consciousness is no longer a person. And I think those are two very different questions.
Are you understanding moral personhood to mean being with full moral status?
Yeah, I'm a pluralist about moral personhood. I'm agnostic about metaphysical personhood.
Okay, all right, thank you very much.
Sure.
Thank you. I am actually going to head toward the audience for a question for Aaron. Aaron, Peggy Mason says that was powerful and righteous. 2 comments, questions. Although I think there may be 3 here. So get your pen ready. First, the groups put together by Harvard and Yale would appear to be somewhere between naive public and acquainted with the experts framework. Useful, but in my opinion, not as powerful as your work with the refusal cases. Second, will there be public engagement with the ULC's work? And finally, do you have any idea through debriefing or preliminary work, which of the possibilities is at work in whether the providers are coming in different or are they changed by their experiences with one of these difficult situations?
I'm going to take the second question first because I think that's the easiest for me to answer. I'm an observer with the study committee, and as Thad laid out, there's the study committee which will make a recommendation as to whether a committee should undertake revision. So there are several steps along the process. I hope that the public will be engaged at some point. I suspect it will be much later in the process in an active way. And he may have more familiarity with that process than I do and might be able to answer that question better. But it is my hope that they will be. In terms of the community ethics groups, I would agree with you that they are somewhere between the naive public and an expert informed group. And I think that that is helpful to the extent that active deliberation on many of these issues requires some level of knowledge about some of the complexities. And that is challenging to do when trying to ascertain general public perspectives. So I think from the standpoint of potentially individuals who have not gone through this process themselves, it is closer to what you might think an educated or informed public view might be. But I agree with you that I think they're only one tool, and I think that refusals cases really are key cases that we need to look at to understand what the dissenting public is trying to say, or what their views are. With respect to the last question, whether there are providers that are coming into this work with already having these changed views or perspectives that make them sympathetic to families who object, or whether they're changing as a result of those cases, I think it's really a combination of the two. And I say that because we have some other data related to provider practices that suggest that those who are younger, so closer to in time to their training, who may have trained more under concepts of thinking about concepts of social justice and racial equity and plurality of opinions, I think maybe coming into the profession with different viewpoints and maybe more sympathetic to families. That being said, amongst colleagues at a couple of institutions, these cases of refusals, and I've had a few myself, I think it's impossible for them not to change you in some way. And I think I've heard anecdotally from my colleagues that their views have changed, including how prescriptive they believe the laws about brain death are. We've talked a little bit about whether these are permissive, like do they permit ways in which a clinician can determine death, or do they require a clinician to determine death by those criteria? That some of my colleagues who struggled with these cases have changed to a viewpoint of these, of at least death by neurologic criteria being a permissive, that the law provides permission to declare death that way, but it doesn't obligate it, and leaves them room for respecting a refusal or obtaining permission or things of that sort. So I think it's a combination of both things.
Can I just jump in on the ULC point real brief? This is being chaired by an Arizona judge, Sam Thuma, and the reporter is a law professor, Nita Farahani. They're doing a terrific job. And I think there are around 70 observers. It's a very large number of observers. And it's very broad, very inclusive. I mean, it includes Jahai McMath's lawyer, who in turn has actually had us hear from Jahai's mother. So I think they are doing a really good job in giving us a broad scope of input, and there's a broad scope of observers. And it may be the case when they move to the drafting committee stage, they may even hold sort of open public sessions. But I just wanted to also say, each state has to enact this, right? And so each state has to introduce a bill, and that's going to go to several committees in each chamber of that state's legislature. So there will obviously be time for public input at that stage as well.
All right, thanks, Thad. We have a question from an attendee who prefers to remain anonymous, just about how is brain death different from leukemia? This is addressed to no one in particular, but to someone on this panel. I do not want your child to have cancer, but she does. How is this diagnosis different?
I'm happy to answer this. I may be one of the few or only clinicians on this particular panel, but I think the way in which it's different is it can be thought about in some of the concerns that have come up, which is there's not a one-step diagnostic test, right, to say you have brain death. That we are here in a 2-day symposium debating things, including the clinical criteria by which the determination of brain death is made. That's not the same with a diagnosis of leukemia, and I think that there's an intuitive difference there on the part of families accepting that diagnosis, to be able to see a blood smear and see leukemia cells, and they can't see that same thing when it's a determination of death by neurologic criteria.
And as you pointed out, there is that category of refusals that come in between the two, because they've had a chance to think, or they've learned something new in between the two. And I think others have referred to those sort of things too. All right, just very very briefly to your, I think, entire panel, because I don't remember entirely whose slides referred to the veil of ignorance. But Christos had posed a question somewhere along the point that's a rather general question. How would defining death, what would defining death look like behind a veil of ignorance?
I mean, as the trained political philosopher on the panel, I can try and take that. Partly because, you know, although I believe Christos is referring to Aaron's slide, which mentioned this, I think actually it's my view which would ultimately require some argument of this kind, right? So I'm trying to say that to define death, you want to define and delimit when your rights in your body begin and end, right? What the boundaries of those are, and you know, although the bit of Rawls I appealed to isn't the bit about the original position, I would be very sympathetic to the idea that those rights should be determined, as I mentioned, by like what's fair to ask of other people, right? And so I think this is well worth thinking about using the tool of the veil of ignorance, right? Because that's a way of trying to achieve a kind of impartiality, right? So if I didn't know whether I was going to be, you know, Jahai McMath or the doctor, right? What rules would I want to use, right? What rules, you know, would I be willing to accept, right? Not only do I not know whether I'm Jahai McMath or the doctor, I also don't know whether I'm that next person who might use that ICU bed, right? I don't know whether I'm any of those different people, right? And so I would think that, although, you know, I don't exactly have an answer to the question, that it's just the right place to look in deciding how to frame these rules, given that, as people have pointed out, it came up in the case of the PICU, that there are considerations of scarcity here. It's not all about just respecting families who want to keep their kids on life support. It's also about respecting the claims of the families whose kids might die without life support if you keep somebody on. So anyway, I think it's a great question. That's a long way of saying that.
Thanks. And I think we have other people who popped up here. Sid and then Lainey.
Yeah, I just wanted to follow up on that because I'm not a Rawlsian, but I will use Rawls when it suits me or suits my purposes. But, you know, I think one of the other things that's relevant from his work is the difference principle. And the difference principle acknowledges that there will be inequality in society and that our approach to that inequality has to be that the most disadvantaged people will benefit the most from whatever unequal structures we decide to organize our society around. And, you know, as Aaron's talk points out, many of the people we're talking about would count as being among the most disadvantaged. As Kimberly's talk, you know, discussed, many of those people who are troubled by this are people who are disadvantaged. And I think we can think about justice in healthcare more broadly than just thinking about it in the way that it classically is, which is distributive justice, where it's basically being used as a scalpel to determine who gets what. And I think that's actually the wrong way to think about justice in this context. And it's a lot more useful for us to think about who might be disadvantaged and who might be oppressed by the way that we are using the law on brain death. And I think the law on brain death started out in this kind of distributive way. We have a potential crisis where ICU beds are going to be used by people who won't benefit from them, for people who we can't really help, and someone else might benefit more. And that is also implicit in the UDDA and in other approaches to brain death. But I think we need to think more broadly about the way justice fits into this whole discussion.
Can I just make a comment in response to that, which I wholeheartedly agree, Sid, with what you just said. And I almost introduced the difference principle as well, but I thought I was hearkening on exceeding my time. So I think that we're standing at a point in time where we have the capacity to revise a law that will have universal application to what it means to be alive or dead, intersecting with a period of time where issues of social justice and racial equity are at the forefront of everybody's minds. And if we don't bring those conversations together, we're losing an opportunity to stand on the right side of those issues. And I realize that that might not be a super philosophically grounded argument, but I do think it draws on principles of distributive justice that I think are important as we're making these decisions.
If I could just throw in just a brief follow-up on that, just it is a really hard question to decide who counts as the worse off for these purposes, though, right? So is the person who will never recover consciousness worse off than the person who might be? It seems like they are, right? So should we prioritize giving resources to the person who will never recover consciousness or to the person who might? Just a caution that this idea of priority for the least well off is a difficult one to interpret, and that it has important ties to contemporary debates about oppression and marginalized identities, but it's complicated.
I think it's
I fully
really
agree.
important in context of scarcity and where we are concerned about scarcity. And that can include perceived scarcity or actual scarcity. I mean, the cases we've talked about here where we have 2 ICU beds occupied by children who are, brain dead. I mean, if we have legitimate scarcity, we can think about who needs that bed more, but we can also think about it in the context of, who's disadvantaged. And there's room for both of those ways of thinking about it.
I would also say that I think that we need to consider whether we ought to re-examine the scarcity question as being embedded in the definition of death. There are definitive problems related to scarcity across the provision of medical care, but I think we hide a little bit behind calling someone dead to address those questions. We are facing these issues in the setting of a pandemic, and determining how to allocate ventilators is challenging. Determining how to allocate staffing is challenging, and we, in many places, had to make decisions in real time about who would live or die because of issues related to scarcity. Those are real problems, but I don't think that they necessarily have to be tied into a definition of death. And I recognize that was one of the initial motivators for the drafting of the Uniform Determination of Death Act, but I think we need to re-examine whether they belong in the same place or not.
Can I ask something, going back to the construct, to the legal construct, and mainly Seema and Erin? I think some clinicians at least would be okay going there and saying, listen, the metaphysics are intractable. There are many values to balance, which is hard to do, but we need a clinical way to determine, where is the end of let's say, biological life. And so we will have to construct a reasonable definition. My question is, first of all, it seems that has to be a transparent construct. The public needs to know what we are doing. And so I want to know how we do that. And how do we allow objection to such a construct?
Erin, do you want to go ahead? This is your panel. Why don't you start and I'll supplement.
Sure. So I think if I understand the question, Christos, and correct me if I've misunderstood it, the question is, how do we tell the public, or how we let the public know this is what we're doing, and then how do we accommodate people who object to it when we declare brain death? I think that it begins with very transparent discussion of what and language that is carefully framed in what we know. So things like this, your child or your loved one has severe neurologic injury. From everything that we know about patients in this setting, this is what we can expect. Recognizing that there's a little bit of room for uncertainty, right? And I think some of the debates we've gotten into are around that area of uncertainty. And I think we need to be transparent where there may be some, little bit of uncertainty around around the conclusions that we make, but using careful language, explaining what we're testing for when we're doing a detailed neurologic exam, and what we expect the consequences of that examination to be. So under the current framework, for me, that means even prior to a first exam, I walk a family through what am I testing for? What is that going to tell me? And what are the consequences of that? And then I'm going to perform a second exam. And at the time of a second exam, if the exam is consistent, your child, your loved one will be declared dead. And how do we allow for accommodation of the, so in terms of how I approach it, that's how I would approach it, is very transparent, honest, sensitive to the needs of the families and responsive to their questions. And then in terms of accommodating objections, I think there are a couple of ways which that can happen. One is if you live in a place which legally permits objections to the determination, you can make the full determination and accommodate that person's beliefs. In New Jersey only can you allow them to exempt from the determination. And if you live in a state where accommodation doesn't exist, the only way I'm aware of now is to view the legal standard as permissive, and not necessarily, if you know the family objects, move to a full determination of brain death, meaning complete the second exam. Some could argue that, and I think Thad pointed this out as a way around the law. It is a way around the law that I think is legally at least acceptable currently, given that there's not a national standard for accommodating. But I think you could have a uniform law that suggests a national standard for accommodating the same practice. Then if that family were in New York, were in New Jersey, were in Georgia, were in Alabama, that person would be alive or dead in any of those states, according to whether that family objected or did not object. So I don't think it completely threatens uniformity, but I think would allow for better accommodation.
Yes, I agree with all that. I think I wanted to kind of frame this a little differently. So one is, I think every clinician right now has the power to be transparent about legal fictions by using the kind of language that Aaron just used and Bob Trug used yesterday. There is the possibility that if we have an unacknowledged legal fiction, that those individual conversations could acknowledge it without using the term fiction, but just explaining what it is that clinicians are doing in a way that is honest and transparent. Additionally, I think the Uniform Law Commission's process is something where we might have the power to influence how that process goes forward. And one thing that I think might be critical for the people at this meeting to think about is that process has not yet determined whether they're going to recommend legal reform. They're still deciding whether there's a way forward. And so I think one of the key issues for groups like this one would be to see, is there something we could all agree on that is a process that a way to reform the law that we think is honest and transparent and, addresses these many controversies in a way that we could all live with. Because I do wonder if this commission were to say, we can't think of a way the law could be reformed that everyone could agree upon. If they just sort of throw up their hands and give up, then we're stuck with the fiction we have now. So that's one possibility. And finally, I agree that the accommodations can just be built into the law to create uniform access to those accommodations is also, is clear from Lainey, Ross, and Bob Beach's proposals.
I had a few of you nodding and making motions as if you were interested. Thad, were you one of those?
I'm so glad Seema said that, right? I mean, there's a lot of people on this call, so this is it, right? Write to Nita, write to Sam, just write to the ULC staff, and they'll pass it on. I mean, second, just on that, go back to that veil of ignorance question. I think one thing that didn't come up in the conference yet is how few people actually die on brain death criteria. It's incredibly small. Right? 3 million people died last year in the United States, way less than 1% died on brain death criteria. And you don't know, right? None of us know if that's the way it will be determined dead. So frankly, I think that everybody who voted on the UDDA in every single state was acting under a veil of ignorance because they didn't know if it would apply to them or not. So I think the original question was, how would this work under Rawlsian veil of ignorance? Exactly the way it is working and has worked.
To that point, Thaddeus, I think that's a really important point to make, that so few people die by brain death criteria. And when we think about the scarcity question, I think that's really important because many people with neurologic injury, we've gotten so good at interventions that they don't actually meet brain death criteria. But their level of interaction with the world, one might question, it's not much different from those who do meet brain death criteria, but they're utilizing far more chronic ICU resources than that population who would object to brain death determination and might utilize those same resources.
Yeah, and real briefly, Bob Trug did this yesterday, but I think one thing we didn't do here is link this entire brain death debate to the medical futility debate, because the question about when is somebody so forget the question about whether somebody's alive or dead, right? There's a whole separate debate about when is somebody so catastrophically critically ill, or when do they have so little neurological function? Who cares if they're alive or dead? The point is they have so little neurological function, it's not worth sustaining their body anymore, right? And hospitals across the country unilaterally withdraw ICU treatment all the time, right? Regardless of the life or death question. And so I think we keep bumping up against this thing about when what is worthwhile and what do we do when we can't get consent. And so I think it's hard, I think, to separate this debate from the medical futility debate.
So I'm going to jump in because I really wanted to talk about roles, but I have to answer you, Thad. I think they're incredibly different debates. So from the perspective that Bob Veach and I had proposed, the criteria by which somebody is determined to be dead was chosen by either the patient or the patient's loved one. This medical futility is about the doctors imposing their view on the patients and the families. So that's point one. Point two is, you said all the time we're withdrawing care over the families. That's actually not the case. In most states that don't have medical futility laws, there are some places where you can unilaterally withhold CPR, but unilaterally withholding CPR does not mean unilaterally withholding and withdrawing all other treatments. So many of those statutes are very limited to just withholding CPR. So I would disagree with you that lots of ICUs are withdrawing treatment, quote, all the time, not over the family's objection, they're not.
Sid, you had expressed an interest in leaping in, and then David, Magnus.
I just wanted to add to what Aaron said and what Thad said, which is that although this is a small number of actual deaths that occur in our country, they do seem to be, the controversy around them is outsized. I mean, I can only speak anecdotally from my experience on an ethics consult service in a hospital, which is that we catch a lot of cases of controversies in brain death in our hospital. And so the disputes about these and what happens to the families in this case, and the disparity in the way different families are treated is very real and is a serious problem for this whole discussion of brain death. And again, gets back to those issues of justice and different treatment that we're seeing.
And David.
So I just wanted to respond about this issue of futility declarations. I think one thing sort of strained in this is there are real differences between pediatric and adult settings. As somebody who does clinical ethics at both hospitals, futility is almost never invoked in a pediatric setting, but in states that make it legal, and even in some states that don't, if you look at the work of like Liz Zhang and some others, it actually is in fact quite common in the adult setting to override the family's wishes and withdraw life support. We do it. We have a law in California that allows that, but we do it quite regularly as a hospital. And one of the things that was mentioned earlier, as we've gotten better, with hemicranies and other things to prevent people from progressing to brain death, we see an increase in the shift from withdrawing on the basis of brain death to making those medically ineffective care cases, which is how it's worded in our statute, and then withdrawing on that basis. And I will say, in some ways, it's cleaner and easier for the families when we say that the patient is dead than when we tell them that there's no longer effective care and beneficial, and that they have a time limited opportunity to arrange a transfer, which almost always fails, after which we withdraw.
So just want to add in here, Lainey, I'm cognizant that you still wanted to go back to a Rawlsian point. So I did want to add one comment here that was from the audience, fourth ad from Casey Davis, just talking about how isn't it unfair, and perhaps it connects to the distributive justice concerns, that we divorce ourselves from determining quality of life and respect a family's decision to trach or vent a kid who is not brain dead under our current guidelines. So the brain death, futility situation does seem to raise some fairness questions to at least Casey.
And this just gets, you're right, this is all about quality of life, but different families value quality of, determine their quality of life of themselves and their loved ones very differently. And that's why I would have taken Rawls back to the original position. And given that question, the answer is that's why we have to have, choice with regards to by what criteria we want to be declared dead, because that's exactly the point. For me, I have a really high value on cognitive, and that's why I want the upper brain death criterion. I know it's going to be a small number of people, and that's good. And I think the number of people who want to be dead only by cardiocirculatory is a small number, and that's good too. And so most of the world is going to be in that middle bubble. But to avoid what we're seeing, which is such disagreement, we could have resolved the Jahi McMath case if we just said, you know what, this is one of those cases that falls that the family doesn't believe in death by neurological criteria. We're done. Trach and vent her and send her home. So I think we do ourselves a lot of harm by not respecting choice in the declaration of death.
I actually see from the Q&A, Casey, if you'd like to clarify, she or he is expressing that that wasn't the concern, and I'm not sure whether it was in my translation of the question from the printed language or in something someone else said. But in the meantime, while there's a chance to do that, I know Erin would like to jump in.
Thank you. Yeah, I just wanted to jump in just to clarify that I think there's a distinction between discussions of use of ICU resources on the basis of futility, and I don't like that language, but thinking about medically not indicated care. I think there's a difference between discussions of resource utilization under that framework and under a framework of how do you allocate resources under conditions of scarcity. Because the first framework allows for declination of individual patient resource use on the basis of what a medical team judges, as Lainey was pointing out, as appropriate or not appropriate, futile or not futile, without regard to other patients. It can just be that they think in that circumstance for that family, it's not, that for that patient, it's not beneficial, and opt to withdraw life-sustaining therapies on those grounds. Whereas when you're thinking about that question under a resource allocation framework, the question only gets triggered by the situation of scarcity in which all resources need to be thought about, and thinking of patients as a whole rather than the individual patient becomes, I think, more justified or justifiable under those circumstances. So I think, while they're related ideas, I do think they're separate frameworks to think about these questions. And I don't necessarily think the futility one is the right one to think about the brain death question, unless you're going to extend that to thinking about all forms of neurologic disability. And then I am in agreement with Lainey's view that I think those are very personal decisions, and there is a spectrum of neurologic injury, the spectrum of disorders of consciousness, and many considerations along that spectrum that play into individual decisions.
All right, although this is a fantastic discussion, I'm afraid our time has run out. I thank everyone. It was a terrific panel, terrific discussion and input from everyone, and we are going to take, I believe it's a 10-minute break. Thank you.
We're doing a 30-minute break until
Oh.
2.
All right, 30-minute break.
So Lainey will get us started at 2 o'clock. Thank you.
Thank you, Kathy.
Thank you
Thank
all.
you.
Thanks, everyone.
Hi, can you hear me?
Hi, so Nair Collins, correct?
Yes, yes, thank you.
Got it, yep.
Um,
You go by Mike or Michael?
Mike, but anything is fine with me. Do you mind if I share my screen right now just to check?
I'm totally cool with that.
Okay.
Yep, looks good.
Okay, thank you.
Can you take it down now so they can put back up the other screen?
Oh, yeah.
I think Jessica has the ability to bump us off if she needs to.
I don't think I'm going to be bumping any of you off.
Is my sound okay?
It's great.
Yes, it's excellent. What time does the debate continue till, Jessica?
Let's see, 2:00, which is now, until 2:50, and then the conversation begins, and then the thing ends at 3:20.
3:20.
So an hour
Okay.
and 20 minutes.
Right, I just needed the 3:20, thanks.
Cool.
Tell me when I'm supposed to start. Yep. So welcome back, everyone. I'm Lainey Ross, and I'll be moderating session 5, Is Death Necessary for Donation? The ethics of deceased donor organ transplantation has been premised on the dead donor rule, which states that organ donation must not kill the donor, but that the donor must be declared dead first. And so today we have 2 speakers who are going to take different perspectives on the whole question of the dead donor rule. So we're going to begin with Mike Nair Collins, whose talk is entitled The Dead Donor Rule and the Determination of Death Act. Professor Nair Collins is an associate professor of behavioral sciences and social medicine from Florida State University. Mike, you have the floor.
Okay. Hello, everybody. Thank you, Lainey, and for that introduction, and thanks to Christos and Jessica and everyone who's been involved in organizing this excellent conference. And thank you to the audience, which is still with us for our final debate and discussion with myself and David. So I'm going to talk about, up till now, we've heard multiple different perspectives and concerns surrounding brain death, but haven't had too much discussions explicitly about the relationship between accurate diagnosis of death by neurological criteria and heart beating organ donation. And so today I'm going to discuss the dead donor rule and the Uniform Determination of Death Act. So the dead donor rule is an informal rule that states essentially that the donor has to be dead. So organ procurement must not cause the death of the donor, or in other words, vital organs, donors of vital organs must be dead first. And this is setting aside living donations such as a single kidney or a lobe of the liver. And the standard justifications for the dead donor rule are as follows. First, it serves to preserve trust in medicine and transplantation because it provides us with a bright line that we will not cross. Second, it is supposed to protect patients from being killed for organs and also thereby protect patients from being harmed from the organ procurement process. And for in response to the call that has been made for many years now to consider abandoning the dead donor rule, the response is that, well, abandoning the dead donor rule would cause or exacerbate mistrust, is likely to lower organ donation rates due to that mistrust. In order to enact it in actual clinical and legal practice, it would require controversial legal changes that are also probably unlikely because it would require changing homicide laws so that a surgeon and the surgical team would not be liable for homicide for causing death for organ procurement. And it would also abandon medicine's fundamental commitment to not causing the death of one patient in order to save another patient, or simply medicine's commitment to not causing death. The debate about the dead donor rule is almost always framed as a question of whether we should abandon the dead donor rule. And the implication of this framing of the debate is that we follow the dead donor rule now, and there's this question of whether we should change practice to expand the pool of potential organ donors. But this framing of the debate, as I'll argue, is not based in reality, and it contributes to false narratives about the credibility and reliability of the diagnosis of brain death, and ultimately is a counterproductive debate in this context. And so in this talk, I want to argue that the dead donor rule has already been abandoned. And what's more pressing ethically is to address that issue than the sort of more in principle philosophical debates about the dead donor rule. Couple notes that I just wanted to point out here. The dead donor rule is ambiguous. So you can't, it's empty unless you specify what we mean by dead in the term dead in the dead donor rule. So as we've heard for the last 2 days, there are multiple different concepts of death that we might draw on. Do we mean death of the biological organism? Do we mean death of the person? And if so, then what concept of person is the operative concept? Do we mean death as a normative word, in which case the dead donor rule would just be a tautology, it would be true by definition? Or do we mean something else? Do we mean, dead according to legal criteria? And for the purpose of this talk, what I mean when I say the dead donor rule is dead relative to actually existing laws in the United States, which is the Uniform Determination of Death Act. So when I say the dead donor rule, I mean dead according to the UDDA, because that's what the actual law is. So we've heard this multiple times. So the UDDA says an individual is dead upon irreversible cessation of all functions of the entire brain. A logical corollary of that is that an individual with any function of any part of the brain does not meet the statutory definition of death. This is unarguable. It's not something that we can debate. It's a logical corollary. Now, one quick another point I wanted to mention as a bit of a setup is the difference between terms misdiagnosis versus mismatch. We've heard again over the last 2 days from multiple speakers about there's a mismatch between practice and the law. I think this is a euphemism that isn't really justified to use. I think that the correct term is misdiagnosis. The reason is, bringing it back to Burnett and colleagues' concept, criteria, and tests, the level of physiological criteria that defines the physiological category, the nosological category that the tests are supposed to be identifying is actually enshrined in the UDDA. That's what the UDDA tells us, that's the category that physicians are supposed to use tests to identify. And that category is irreversible cessation of all function of the entire brain. Hence, if a patient were to be declared dead under the UDDA, but have some function of some part of the brain, then that would be a false positive misdiagnosis, because that patient does not, in fact, meet the physiological criteria or legal standard that physicians are supposed to be testing for. So I hope that's clear. Now, I'm going to focus specifically on the hypothalamus and specifically on osmoregulation for the purpose of this talk, partly because, because it's the most obvious case, basically, but also because the hypothalamus over the last 30, 40 years has gotten a sort of a bad rap in the whole literature on brain death. It's been dismissed repeatedly as sort of not mattering, and so I'm here to stand up for the hypothalamus. So just for a general beginning, so Hal Blumenfeld in Neuroanatomy Through Clinical Cases writes, the hypothalamus is the central regulator of homeostasis and has been informally nicknamed the homeostatic head ganglion. The hypothalamus maintains homeostasis in the body by interacting with and exerting important regulatory influences over other systems, thereby participating in homeostatic mechanisms, endocrine control, autonomic control, and limbic mechanisms. Taking a look more closely now at osmoregulation and diabetes insipidus. So the term osmoregulation means the regulation of osmolarity in the extracellular fluid, which is the concentration of solutes within the water. And the most common is salt. So it's basically the regulation of salt and water concentration in the extracellular fluid. How this works is, so there are magnocellular neurons in the paraventricular and supraoptic nucleus, and they secrete ADH or antidiuretic hormone, which is also known as vasopressin, via the posterior pituitary, in response to as little as a 1% change in extracellular osmotic pressure. And it maintains plasma osmolarity within a very narrow window of about 3% through a negative feedback process by regulating diuresis or the release of water through the kidneys. Importantly, the half-life of ADH is about 15 to 18 minutes. So what that means is osmoregulation is maintained within a narrow window on an ongoing basis. And if the hypothalamus was entirely non-functional, these nuclei would not be secreting vasopressin or ADH, and the result is diabetes insipidus, in which you have the release of very large amounts of pale urine, basically polyuria, because antidiuretic hormone is antidiuretic. So without the antidiuretic, you just get massive amounts of diuresis. Now, I'd like to take a slightly even closer look. Bear with me for just a moment, because the details do matter. So let's take a look at this figure here, starting at the top. This green oval up there is to represent the hypothalamus, and within that oval are these little things that are supposed to look like neurons, the paraventricular and supraoptic nuclei. Those neurons are osmoreceptors, which means that they respond directly to changes in osmolarity in the plasma surrounding them. Basically, they shrink and swell, and these little stretch receptors open and close as a result of that. But importantly, the depolars and as they open and close, the stretch receptors, ions come in and depolarize the cell. But depolarization enough to to hit threshold potential and cause an action potential down the axons, especially in the supraoptic nucleus, the localized changes is not typically enough to do that. There's a secondary set of osmoreceptors that are located in circumventricular areas of the brain, which is very close to the hypothalamus, particularly the organum vasculosum of the lamina terminalis, or OVLT, and the subfornical organ. And these neurons are osmoreceptors as well, and they work the same way, but they don't secrete vasopressin. Instead, they secrete glutamate to the the neurons here in the supraoptic nuclei. And so what you have is the additive effect of the localized depolarization plus the glutamatergic excitatory effect from the other cells in the circumventricular areas. And then given depolarization, then it travels down the pituitary stalk. And then this is the pituitary, the posterior pituitary on the right, releases vasopressin into the pituitary fossa, and then over into the cavernous sinus, makes its way out into systemic circulation via the jugular vein, and then it can hit the kidneys and act on that. So there's two key points I want to take away from this figure. One is functional and one is anatomical. Functionally, normal osmoregulation is a function of a combination of the neurons in the magnocellular neurons in the hypothalamus and neurons that are osmoreceptors in the circumventricular areas. Anatomically, I want to point out that the posterior pituitary is comprised of axons whose cell bodies lie up here in the hypothalamus. All right. So how common does this happen? In the largest clinical series that I'm aware of, and in good faith, I believe is the largest clinical series that exists, Dr. Jaffe and I completed very recently, examined hypothalamic function in brain dead patients, and of 2,546 patients diagnosed as brain dead, 1,265 were reported to manifest diabetes insipidus. So half had diabetes insipidus and half did not. This is a forthcoming chapter, so it's not out yet, but you could email me or Ari for the paper. But if you're interested in something that's already out, you could see this this citation here from 2016, which found basically the same thing. So in spite of its description in medical texts and scientific texts as a critical regulator and integrator of vital functions, in the brain death literature, the hypothalamus apparently doesn't count. We just kind of discount it as if it's not important. So why has this happened? Why is the hypothalamus, or what are the reasons that have been given over the years for why the hypothalamus has been essentially demoted from the homeostatic head ganglion to being irrelevant in the brain death literature? So turn to that, and my alternative title is In Defense of the Hypothalamus. So the one that's been mentioned several times today and yesterday is this extradural blood supply. So this is important because the basic mechanism of brain death is a self-fulfilling or a positive feedback process in which intracranial pressure increases and blood flow to the brain decreases, causing more intracranial pressure, et cetera, eventually resulting in intracranial circulatory arrest. However, a key detail is that more than the cranium itself, it's the dura that is the inelastic container within which pressure rises. So if there are parts of the blood supply that are outside the dura, then theoretically they are protected from that extra pressure and would have allow more continued perfusion. And the hypothalamus pituitary does have an extradural blood supply. The claim is, though, therefore this function doesn't count, but that's irrelevant. Just because we have an explanation or a purported explanation for why we find this doesn't mean that it doesn't count. It just means that we have a reason to expect it. The UDDA doesn't say anything about blood supply. It just says that all brain function must cease. The second point I want to point out here, which is relevant beyond thinking about the hypothalamus, is that it doesn't explain continued osmoregulation anyway, because as we saw earlier, it's the inferior portion of the posterior pituitary that has an extradural blood supply, and these are the axons. But the cell bodies that measure osmotic pressure are all located intradurally, and hence are not in areas not protected from increased intracranial pressure. So I'll go over this one a little more quickly because I realize I'm already back on time. But so there's 4 arteries that go into the brain. There's carotids, the vertebrals in the back, And the internal carotid takes sort of a winding path outside the dura for a bit. While it's outside, something called the meningiohypophyseal trunk pops off of it, and then another branches off of the inferior hypophyseal artery, and they pierce the dura here. So you get a protected blood supply all the way up to, obviously this is a representation, I don't know exactly there, but you get a protected blood supply all the way up into the, because this dark blue here is the dura. The dura goes down the diaphragmacella and wraps around the pituitary. But this supplies blood to, the posterior pituitary, parts of the pituitary stalk, maybe the median eminence located right at the top of the pituitary stalk. But it doesn't supply blood up here in these areas that we talked about before, and certainly not over to the circumventricular area. So the fact that we find continued osmoregulation in half of patients shows that there has to be some continued blood supply. The idea that in brain death that you have intracranial circulatory arrest, this is an assumption. This is not a demonstrated fact, and this has relevance for some of the other concerns that Dr. Jaffe was talking about yesterday, but I'm not going to go into that. The second reason that folks have given is that it's an activity, not a function. It's just secreting something. It doesn't really count. This is clearly not true. This is from the Guyton and Hall's textbook of medical physiology. For the cells of the body to function properly, they must be bathed in extracellular fluid with a relatively constant concentration of electrolytes and other solutes. The total concentration of solutes in the extracellular fluid, in other words, the osmolarity, must be precisely regulated. And it goes for all the cells of the body. So to claim that osmoregulation doesn't count as a function is clearly false. I'm going to move more quickly to others have claimed, well, it's not an integrated function. It's not sufficiently integrating things within the rest of the organism. And this is just, if anything counts as an integrative function, then preserving the chemical composition of the extracellular fluid, which is required for essentially all cellular functions throughout the body, that clearly counts. In Candel's text, they write the hypothalamus integrates behavioral, autonomic, and neuroendocrine responses involved in 6 vital functions. More importantly, again, this is irrelevant because the UDDA doesn't say anything about which ones count and which ones don't count. Another reason that's been given is that it doesn't count because it's not a clinical function. This is, again, irrelevant because the UDDA doesn't specify which functions count and which don't. This is all brain functions. It's doubly irrelevant because the diagnosis of brain death is not a clinical diagnosis in spite of its being advertised that way. You have to rule out confounds, which involve laboratory tests. You have to identify the cause of coma, which involves an imaging test. In order to do the apnea test, you have to measure arterial blood gases, which is a laboratory test. So it's just not true that brain death is a clinical diagnosis. It's a highly technical diagnosis, just like any other diagnosis in the ICU. And it's triply irrelevant because normal urine output is a clinically observable sign of brain function anyway. More recently, there have been, and Thaddeus Pope mentioned these 2 articles in the last talk. Lewis and colleagues wrote these lawsuits that they were discussing, raised the question of whether the pituitary and hypothalamus are part of the entire brain. And this is just a non-question where we cannot have a debate about whether the hypothalamus is a part of the brain. That's just not open for debate. In the longer form version of the paper, they write, however, the authors of the UDDA do not appear to have intended the phrase all functions of the entire brain to encompass functions of the pituitary gland and hypothalamus. In their 188-page report, they mentioned coma 100 times, brainstem 22 times, and apnea 9 times. But not once did the commission mention any terms to describe pituitary hypothalamic hormonal function. Well, they didn't mention the internal capsule or the dorsolateral prefrontal cortex either, but that doesn't mean they don't count. We don't need to count words in this, important document to figure out what the meaning of the UDDA is. It's clear. And this is the last. So the American Academy of Neurology recently, 2019, put out a position statement claiming that the AAN endorses the perspective of the UDDA that brain death has occurred when irreversible loss of all function, including the brainstem, has occurred. However, the AAN endorses the belief that preserved neuroendocrine function may be present and is not inconsistent with the whole brain standard of death. This is a logical contradiction. It cannot possibly be true, or in other words, as a philosopher would say, it's false in all possible worlds. We cannot have a debate about whether some brain function is consistent with no brain function. Am I running short on time, Lee? All right, let me wrap this up. To review, the diagnosis of brain death is not reliable. There are many false positive misdiagnoses, and therefore, getting to the key point, the dead donor rule is routinely violated. However many of them actually become organ donors, we don't know, but we can say some substantial portion. So the best way to be trusted is to be trustworthy, right? Do what we say we do, follow the law and the dead donor rule, unless and until laws are changed. And we need forthright acknowledgement and discussion of these uncomfortable facts. I'm going to skip through this. The dead donor rule was supposed to be a constraint on behavior. But once it became well known that patients declared brain dead could have some persistent brain function, neurology, critical care, and transplantation societies did not make the choice to alter diagnostic practices to adhere to the UDDA and the dead donor rule. Instead, we've seen decades of ad hoc reasons for why we could ignore this brain function. So we've, in fact, crossed the bright line anyway. So I'm going to skip this because I apologize. I went far over my time. The conclusion is there is a persistent misdiagnosis of death under the UDDA. Public-facing neurology and transplantation has continually ignored or denied this fact and has not changed practices to become adherent with the UDDA and hence the dead donor rule. And so I think that this concern is more pressing than the in principle philosophical discussion about whether or not to abandon the dead donor rule. Thank you. And sorry for going over time.
Well, thank you. Thank you for that very interesting talk, Mike. Now I'm going to introduce Professor David Magnus, the Thomas A. Raffin Professor of Medicine and Biomedical Ethics and Professor of Pediatrics and Medicine at Stanford University, where he is also the Director of Stanford Center for Biomedical Ethics. And the title of his talk is The Dead Donor Rule, A Pragmatic Defense. David, you're up.
Thanks, Laney. And I assume everybody can see this. Thanks very much for inviting me to this wonderful conference. It's been very interesting, and I really appreciate the opportunity to have this ongoing discussion about all these different issues. So the dead donor rule, we've already heard, I think Michael covered it pretty well. There is some ambiguity and some extensions of it, but ultimately it's really the idea that you can't remove organs necessary for the life of the patient, or another way of putting it is it prohibits the intentional ending of the life of the patient through organ removal. Now, I have an easy task in some ways in defending the dead donor rule, because the dead donor rule is just a special case of voluntary active euthanasia, i.e. murder. And so I just have to defend the view that murder is wrong. So I have a pretty easy task ahead of me. I'm going to just start ethically. I think just since the dead donor rule requires voluntary active euthanasia, I do think a lot of the arguments in favor of legalizing voluntary active euthanasia are on fairly shaky grounds. A lot of the arguments focus on the moral equivalence of voluntary active euthanasia and withdrawal of life support. But of course, withdrawal of life support is grounded in the right of patients to refuse unwanted treatment and to give an informed refusal. All physicians, clinicians have to respect the refusal of a patient for unwanted treatment or they commit battery, unlike voluntary active euthanasia, which even its proponents think some physicians or clinicians are allowed to honor, but not everybody is required to. So there has to be a distinction between voluntary active euthanasia and withdrawal of life support. Bernie Gert and I think Jim Burnett and others have made this argument very clear over the years that the distinction between refusal and a request captures and maps out the difference between killing and letting die, which makes a pretty strong argument against voluntary active euthanasia, or at least it undermines one of the arguments in favor of it, one of the main arguments. There's still other justifications, even if they're not equivalent, primarily grounded in autonomy, although again, I think that has some similar problems because of the fact that some of it requires action by clinicians. I'm not going to belabor this anymore, except to just say, at best, this is voluntary active euthanasia is quite contentious in general, but more importantly, it's absolutely a non-starter currently in the U.S. So voluntary active euthanasia and hence violations of the dead donor rule is unlawful in all 50 states as a violation of homicide laws. The current legal landscape in the U.S. is changing in some ways with physician-assisted death spreading, but even the laws that legalize that demonstrate deep ambivalence towards the practice. As somebody involved in setting up our processes at Stanford, it is quite intentionally made to be a very, very burdensome process, reflecting the deep ambivalence people have about its legalization. There's no evidence of major legal and social shift necessary to legalize active euthanasia and hence abandonment of the dead donor rule. And even in the countries where voluntary active euthanasia is legalized, they have not, like Canada and the Netherlands, they have not abandoned the dead donor rule, suggesting this will be the last place where this large social change will happen, not the first. So what are the primary arguments against the dead donor rule, given all that's lined up against it? Well, I think there's some utilitarian justification. We could get more organs, and I'll just touch on that very briefly. But I think the primary argument, which is an argument that Michael has made both elsewhere and in the talk he just gave, is that brain dead patients and many people think donation after circulatory death donors are not really dead, so we already violate. That's really the main argument. We already violate the dead donor rule, and so therefore we don't have to worry about it. I'll just briefly touch on the utilitarian argument. Robertson recognized and rejected this justification. Many aspects of our transplant system are not consistent with utilitarianism, such as the way we give organs to the sickest patients. We'd get more bang for the buck if we didn't have patients with such high MELD scores that we give liver transplant to. We might not even have certain parts of transplantation when you add up cost per quality. And so I think the selective utilitarianism is problematic, and it's only really plausible as a justification once you've already accepted that the DDR is already violated and doesn't make much sense. So really, what a lot of the people who have objected to this have made the claim, and we've seen this over the past 2 days. Michael didn't make it as explicitly here, though he has made it elsewhere, that we should not accept that patients who are brain dead are really biologically dead. And over the last 2 days, we've heard a lot of people talk about this notion of biological death and the claim that that's in contrast to death by neurological criteria. And this notion of biological concept of death, which I think corresponds to a large extent to the concept of the death paradigm that Jim Burnett used to hold. I'm not sure that he does anymore, given his comments yesterday, but it really focuses on this idea that a biological concept of death is really the idea that there's an event, not a process, an instantaneous moment of death, and there's no in between. All organisms are either alive or death. That this corresponds to our common sense understandings of what death is. This is not a social construct; it's a biological thing in the world, and it's the same whether for humans or other higher vertebrate animals, or maybe even all organisms, and that it's irreversible. And we've heard a lot of this kind of talk over the past 2 days. And then the question becomes, does the notions of death that we currently have, namely the cessation of the functioning of the organism as a whole, as established in the or codified in the law in the UDDA, as well as irreversible cessation of the functioning of respiratory and circulatory functioning as the criterion for that, is that really, does that meet that standard? And then there's the tests to obviously draw the appropriate line. And my claim is that any attempt to draw the line to meet those conditions for biological account of death will fail. And here I'm really revealing my past recovering history as a philosopher of biology. I think critics, it's set up to fail because critics of brain death merely have to show that any criterion will fail to constitute a sharp boundary that constitutes cessation of the organism functioning as a whole. No other lines have been drawn that meet the standards set by the death paradigm, is what I'm going to claim, and that it's implausible that the notion of the folk biological categories of life and death would actually name natural kinds. For example, at least one of the speakers referred to circulatory death as true biological death, but it is clearly not in this sort of real thing in the world biological either, right? Because when is cessation irreversible? In actual medical practice, there's a huge variation in terms of after there's the cessation of circulation, how long it takes before somebody's declared. For patients where the outcomes are seen as highly likely to be problematic, and there hasn't, and where those institutions don't allow unilateral DNRs, they often use fast codes where they do just a single cycle and call it after 5 minutes. Sometimes people will continue to try. There's variation according to different practitioners. So there's variation in practice. Maybe that's just an epistemological problem or a practical problem, not a metaphysical one. But I think the deeper metaphysical problem is that where you draw the line of what counts as irreversible depends on what technology exists and is available. Once you have ECMO, what is potentially irreversible changes, and potentially future technologies could change that even further. So that suggests that the irreversible cessation of circulation is itself not a biological line at all, but something tied to our technologies and what we can do as well as our practices. And this idea that these are social constructs shouldn't be scary, because this is actually really common in biological sciences. This is nothing strange or terrible about brain death or other parts of medicine. This is true in biological sciences. Linnaean taxonomy and the division of the natural world in the way that we do in biology, there's pretty universal agreement that kingdoms, classes, orders, genera, and so on are not are conventional or socially constructed, not sort of real or in carving nature at the joints. There's some debate over whether species are real, but for the most part, even that is pretty problematic. Almost everybody's given up the idea that species are real for plants, for fungi, for many microorganisms, for many other kinds of things, and even for vertebrate animals, where it's the closest thing to being plausible. You still have problems because they decide for certain organisms like polar bears versus brown bears, all you need is a reproductive isolating mechanism, which is sometimes seen as a definition for distinguishing species, is preference for different areas, while other things, organisms that are seen as distinct species, are not seen as distinct species, might require as many as like 3 or 4 isolating mechanisms. And you kind of jigger the how many and what kinds of isolating mechanisms are required to more or less correspond to the intuitions and consensus of the scientific community about how we draw these lines. Cladistics has been leading to changes in the way taxonomy is being done, but it continues to push towards recognizing actually a continuum, and the idea that our classifications on top of that continuum is really in some ways but boundaries that are conventionally defined to capture the continuum of what actually happens in evolution. And of course, to a large extent, human interests play a huge role in these classification systems. A friend of mine who's an invertebrate biologist said the fundamental distinction between vertebrate and invertebrates as a major taxonomic category, which it currently is in our current way of thinking about it, is like dividing the world into a portion of my kitchen and everything else in the world, because there are just so many more invertebrate species and organisms by a large number over vertebrates, but we're not that interested in them. And so that's influenced the way we divide up the world. So I want to really build on Ron Green's insights about the beginning of life. Biological occurrences are processes, not events. There's no such thing, for example, as the moment of conception. We sometimes talk like that, but there isn't any such moment, because the sperm comes in contact with the zona pellucida, then it enters, then the zona pellucida hardens after that, then it goes and the sperm delivers the DNA to the nucleus, then it plays a role, but only after a couple of cell divisions. It's a process, right? And for social and legal reasons, we sometimes need sharp lines. So defining what lines matter for moral status is a decision to be made, not a fact to be discovered. The fact that there's no moment of death means that we have to decide what lines we're going to draw. and recognize that there are losses to expanding the range of those with full moral and legal status. So to give an example, think about adulthood. Yeah, there are biological and psychological processes that are undergoing development as kids develop and mature into being an adult. But that process is a continuum. A socially constructed line needs to be drawn for various purposes. So when can somebody vote or enter legal contracts or join the military without parental permission? And it's not disconnected from biology and biological development, but where you draw the line in a continuum is a conventional line that is socially constructed. And I would argue that death is like that. Organ systems, some of them critical, are lost. Eventually, depending on what kind of supports are provided, more organs, including the brain, is lost. And eventually all our cells die unless those have been immortalized in a lab. And if you actually look at biologists who've written about the concept of death and this idea of the organism as a whole, and many of the classic works about that, you see that same notion of a continuum rather than the idea of this sharp boundary. Jacques Loeb and Pearl and others, it's important to note when they talked about the organism as a whole and were talking about their criteria, they were mostly talking about how we distinguish living things from non-living things, not how to distinguish life from death. But when they do talk about death, they tend to recognize it as a process. So he says, we're not worried about definitions, but of prediction and control. In the face of loss of respiratory functions, heartbeat ceases, gradually different tissues undergo dissolution characteristic of death, and goes on to explore the different rates at which different cells die when deprived of oxygen. Raymond Pearl's biology of death really focused on why do things die, why do they die when they do, like why do some organisms live longer, and understanding the answers involves understanding the structural and functional changes that slowly take place and lead to aging and death. So scientific fields that have defined life concerned primarily with distinguishing the living from the non-living is important. And I'll say even about those things, debates still rage, even about how to draw those distinctions between living things and non-living things. I was working on, had the opportunity to consult with some researchers at NASA who were trying to determine whether they were finding life in probes on other planets, in particular Mars. And they started with definitions that they thought would define what finding something alive was, when they actually found something that met those conditions and intuitively they didn't think it really worked, they actually gave up the definition and changed it, suggesting that a lot of these debates really are, which are being framed as top down from essentially metaphysics on down, are really casuistical and often based on judgments about whether a particular case counts as alive or not, and going up as much as it goes from top down. So there are competing concepts of this notion of biological death that are in the literature. We've heard Jim Burnett talk a little bit about the loss of critical emergent properties, and as well as the death of the organism as a whole. Michael, in some other work, has talked about the point where entropy overcomes homeostasis. I want to claim that at a fundamental level, whether it's appealing to the idea that real death is cessation of circulation, which people have advocated for, although I've already indicated why that's socially constructed as well, or any of these concepts, that these are fundamentally metaphysical concepts of the meaning of death, not biological. So I just think we should get rid of all talk of like real death as biological death. Those are just metaphysical commitments that other people have about what they believe death really matters in the determination of death. And the way Michael is saying, in his view, the hypothalamus matters a lot, and therefore to him, metaphysically, he thinks that's essential to something being alive. So different conceptions of the line between life and death. There's the medical neurological definitions, philosophical approaches tied to the loss of personhood and questions of personal identity, legal, when is there a constitutional person, social, when is a spouse single. So Laney and Bob Veach distinguished legal and biological concepts. Howard Brody had multiple concepts, but biological or ontological death doesn't, I think, really do any positive work. It's mostly invoked as a negative, saying not that. So question really then becomes, once we accept that given the continuum and that we have to draw a line, much like adulthood, can we find a line that works to do well what most mostly we want it to do as a practical matter. We want it to function adequately to observe important social functions associated with death. We want it to settle important questions regarding legal status. We want it to be plausible that a person who existed has been irreversibly lost. We want it to be plausible and socially acceptable that such individuals are no longer part of the moral community. We want to allow socially important activities of organ procurement and unilateral withdrawal of life-sustaining treatment to take place. And we want medical standards that can be applied in a timely and reliable fashion without false positives when done properly. And I think brain death does a very good job of meeting all of those things. Line can be accurately drawn with no false positives done properly. Line can be done in a timely way. It leads to irreversible loss of personal identity, even to people who have been critics. Permanent vegetative state, which might actually imply the loss of personal identity, is a line that is not reliably drawn and is not drawn in a timely enough manner to be a practical way of drawing that line. So now the last question I want to just address briefly is which again, several speakers have alluded to, is if we accept that the line between life and death, including then brain death as well as circulatory death, are constructed, do we have an obligation to be transparent about these concepts to our patients? And I would argue that the answer is no. Our nosologies are also socially constructed criteria. We define some diseases by the things that organisms that cause them, like influenza or flu. Some are we define by the physiological effect, like pneumonia caused by bacteria, viruses, and fungi that cause inflammation in the lungs. Some by signs and symptoms. It's not really a very theoretical coherent system, but it works pretty well, and there's historical reasons why things got divided the way they do. So it's a constructed taxonomy. Does that mean we have a duty to tell patients when they go to their physicians, or make it very publicly accessible, that when your physician says you have a certain disease, that this reflects something, a classification system that is socially constructed? Now, Michael Nair Collins argued in a piece that came out of the 50th anniversary conference at Harvard in 2018, argued against my argument here, saying that the analogy between nosology and a life between life and death is spurious. One's deep religious values are not implicated by actions we take on the presumption that one does or does not have the flu. There are no legal challenges to the diagnosis of flu, and death is far more important to the flu. Unfortunately, I don't know that we can really say that today. Whether COVID is real is in fact now disputed by people. There are legal challenges related to its ontological status. It matters deeply to some people's political convictions. Whether someone does or does not have COVID is clearly very important. So if one person's modus ponens may be another person's modus tollens, but if Michael is to be consistent in saying that any of these kinds of socially constructed divisions that are important to people in all these different ways, we ought to be telling everybody that it's socially constructed, would seem to imply that this is something that ought to be done. And I think that is a mistake and potentially a dangerous one, and in fact, something that we probably should not be doing. So my argument is the fact that we can have these very interesting philosophical debates is especially interesting to people who are interested in the philosophy of medicine, maybe some people in bioethics, but that nothing much follows prescriptively from recognizing that the line is and has to be socially constructed. Brain dead patients are really dead, and we should think of them as dead. They just aren't really dead, but so what? And so this is a defense of the status quo. The line is conventionally drawn, carries philosophical and legal implications. Brain dead patients have permanently lost personhood. Organ procurement and avoidance of burdensome care are among the good reasons for drawing the line, and it's well entrenched legally and medically. Now, Michael points out the lack of fit. I don't think it's fair to say that. I think he overstates the case, that saying that the fact that there's some challenges and lack of fit between the current criteria and the way in which a natural interpretation of the law is written, although there's some ambiguity since the law does specify to be in accord with current medical practices, I do think that is a challenge, and I would favor eliminating potential ambiguity that currently exists by specifying, so that we can avoid the problem of making it clear that the hypothalamic functioning does not in fact cause a problem, and that we in fact do in a sense support the actual AAN guidelines that are and the international guidelines, and that should be essentially how we actualize defining what counts as death, very much in the lines of the way that Bob Trug had suggested yesterday, and that had suggested earlier today. That does leave the hypothalamus out, but as I've suggested, this is a decision that people can make about where it's most appropriate on different pragmatic lines to draw the line. And I would say it is very well entrenched to think of brain death in the way we currently do as dead. There's a concept in philosophy of biology by Bill Wimsatt called generative retrenchment. And the idea is that there are certain things that are sort of on the top of a stack of book, certain concepts that you can pull out and it's not a big deal, things you can abandon. Brain death is not one of those. This is very well established with a long history and a lot of current practices built on it. And you risk, if you pull out a book that far down in the stack, having all kinds of unintended consequences and problems. And so I would just make an appeal that the status quo works pretty well and that we ought to continue. Maybe we can tweak at the margins by bringing the UDDA into better fit with AAM practice in a way that's unambiguous, but that is the right way to look at it. Thank you.
Thank you. So we have lots of questions that are coming up. So thank you for these two very provocative talks. I want to start with Sean, who had a question for Mike.
Yeah, I guess I just wanted to ask you to defend, or at least reiterate if I missed it, your standard for what counts as a brain function, right? So seemed to me, I saw a lot of diagrams, it seemed very clear that you established that hypothalamic functioning happens within the brain, maybe that it's brain tissue that performs the function. But it doesn't seem to me to obviously follow from that it's a brain function, right? Like you might think that the functions of an organ are defined by what that organ is sort of supposed to do in the hierarchy of the organization as a whole. And it seems like you could have any number of different accounts of what the function of the brain is, right? And then a function occurring in the brain is only a brain function if it has the right kind of relationship to the function of the brain, whatever that is, right? So it just seems like there's no obvious reason why in interpreting the UDDA we need a spatial or even mereological account of what makes a function a brain function.
Thank you for that question. I think that the more important point of, rather than giving a large scale philosophical theory about the nature of functions and relating this particular function to the function of the brain, I don't think there is any such thing as the function of the brain. I think we can just say, look, this is standardly accepted medicine and science in every other context. No one suggests that osmoregulation is a mere activity and not a function. It is only in this particular context where suggesting that it's not a function plays an ad hoc role in allowing us to ignore the continued brain function. And so, my suggestion is it's a function. Everybody says it's a function, except in this particular debate.
Christos?
Yeah, I just very brief. Can I just do a very brief follow-up? Just
Sure.
My suggestion wasn't that it's not a function, it was that it's not a brain function. And I don't know that that's true, but I just wanted you to defend the idea that it's a brain function. To give your criteria for saying, granted it's a function, why is it a brain function and not a function that happens to take place within the physical confines of the brain?
Well, it's a brain function because it's, it is manifested as a part of the brain, first of all. Yeah, I have a hard time knowing how if it's not a brain function of the brain, then what would it be? I guess I don't really know how else to answer it other than that.
Christos?
No, sorry, I don't have a question. I think Fernando had one.
Okay, Fernando.
Thank you. A question, comment I would like to hear from Mike in regards to the osmoregulation. A little bit continue with the prior topic. There's a osmotic and non-osmotic release of vasopressin.
Yes.
And on top of that, many of these hormones are released in a tonic fashion and a pulsatile fashion as well.
Yep.
And therefore, the fact that the ADH be stored in the posterior hypophysis that receives extradural flow and is part of an extradural organ may justify why DI may not develop initially in the early stages after the diagnosis of brain death or around that time, right?
Right.
So none of these patients, they are all in the ICU and no one challenges them with dehydration or hypervolemia to see what happens with the urine output. They are tightly controlled, and therefore there's no reason for significant changes in the ADH that might be present already in the hypophysis and not necessarily in the hypothalamus. And the second point I wanted to make and see what your opinion is, there's an interesting paper by Japanese authors published in 92, where they looked at 30 patients or around 30 patients that were pronounced brain dead and had cerebral angiogram, proving cerebral circulatory arrest. And they looked at the hypothalamus in the autopsy and they looked at the hypophysis, but they also measured ADH before and when they made the diagnosis of brain death. In all of those cases in which they measure ADH, antidiuretic hormone drops trepidatiously right at the time of diagnosis of brain death, sort of proving that really when you measure it, it goes down. Our personal experience, as I showed, unpublished data, is that when you do transcranial Doppler and prove intracranial circulatory arrest, 90-something% of the patients fulfill clinical criteria for DI.
So the first point is also known as posterior pituitary washout, right? The idea that there's antidiuretic hormone sitting in vesicles and it sort of passively releases and that is certainly a possibility, and it could potentially explain some of what is observed. But when we think about the importance of the ongoing regulation, so there's a tonic release of ADH that the action of the osmoreceptors in both areas either lowers or raises depending on the osmolarity in the blood, and to maintain it within a 3% window, and it's implausible that the passive release of this would be able to maintain this function. It has to be a negative feedback system. And the second point is about blood flow testing. Well, every test has a limit below which it cannot measure. All we can say is that the blood flow testing, blood flow is below the limit of detectability. But if you still see continued lack of diabetes insipidus for a reasonable period of time, that has to suggest that the hypothalamus and circumventricular areas are still functioning and receiving blood on an ongoing basis. And then the third is I wanted to point out the paper that Ari and I put out is a compilation, but there are multiple papers that were very well done studies that correlated urine output with hypernatremia, with measure of sodium and other diagnostic category of diabetes insipidus, and found it within the range of normal osmoregulation. So I don't think we could say that posterior pituitary washout explains all of the findings. I don't think that the evidence shows that.
Can I make a very quick comment, Lenny? Oh, sorry. I have the feeling that this debate about the neuroendocrine function, especially when it refers to ADH, is based on a lot of reports, but serious science has not been done or redone in the last few years. And
well, that's what I was just mentioning. So I could send you several papers that, I'm sorry to interrupt. Go ahead.
No, go ahead. And I just wanted to say is that there's a great opportunity that is patients who are organ donors that are maintained in the ICU for at least a day after the declaration of brain death, and to understand very well what happens, not at the time of declaration, but hours or days after.
Right, and many of the articles that are included in the compilation are also from Japan, when during the 90s, if you remember, there was a lot of research coming out of Japan because of they wanted to make the change to brain death, and there was a lot of research where they had patients who were maintained on life support for longer periods, 2 weeks and such. So there is some good science out there that looks at this, and I'll be happy to send you some of that.
So I want to take 2 comments from the audience and then turn to Sid about what you're saying, Mike, and then we're going to have some questions for David. The 2 comments were Casey Davis said that she agrees with Sean. What about the rest of the endocrine system that is not housed intracranially? And Kenneth Prager sort of follows up. The hypothalamus is anatomically part of the brain, but seems to be involved with biological survival and not with personhood. So take those 2, and then I'll turn to Sid.
Is this for me or David? Do you want?
Yes, for you. We're playing with the hypothalamus, which is what you wanted.
Well, good. Yeah. Yeah, I want to be clear, and also in bring in a response to David's excellent talk. I didn't make any claims in this particular talk about biological death or about whether death is socially constructed or not. The only point I wanted to make was to show that the bright line that it is socially constructed, which is the law, of course, is socially constructed, is something we jump over. And if that's not, if we say we have a bright line, then we should follow that bright line. No, as terms of, I don't know whether the hypothalamus is part of personhood, but I don't know what personhood is either. So I don't have much to say about that. Then the other part was a question about the remainder of the neuroendocrine system. There's also a lot of evidence, which I didn't discuss, regarding functions that are subserved by the anterior pituitary. And we don't see central adrenal failure or central thyroid failure, which you would expect to see if, say, the median eminence was destroyed or was non-functional. So there's more evidence out there to say. I just wanted to give a more focused discussion.
Great. Thank
Can I
you.
say something in response to that, though? I do think that it's a little bit uncharitable to the AAN and to the people who have defended their view to say that it's just, simply demonstrably false and incoherent. I mean, it is not inconsistent to say that a concept in one context can be thought of one way and in a different context can be thought of in a different way. When physicians define what counts as being terminal with a 6-month or less prognosis for the purposes of hospice referral, they often have very different standards and mean different things than when they have the same diagnosis for the purposes of referral for physician-assisted death or the End of Life Option Act. And in fact, as a result of that, they in fact have very different standards where a very same physician who might say one patient is eligible for hospice is not eligible for the other because they have different levels of probability that they feel is required for the different things. So I don't think there's anything contradictory to say that in most textbooks and most contexts, the hypothalamus is part of the brain, but in certain other contexts, like determining brain death legally, that it's contradictory to say for those purposes, that's merely, that's a function, that's not a brain function. And I think Sean in the chat is a nice illustration of what that could be. You could say it's a function, but the things we really care about that really are driving us to make this decision about what matters for brain death, this is a function of something, but it's a function of something that happens to be housed within the brain, but it's not really a brain function for this purpose, even though in other kinds of biological purposes, we might think it is a brain function. And so I don't think there's anything contradictory. It may be not optimal from a point of view of clarity. And so it might mean, as a matter of prudence, that would be appropriate for the law to change in the ways that Bob and others have suggested, to make it clearer and to make it easier for judges to interpret. But that's a different thing than saying that definitively the dead donor rule is routinely being violated, which I don't think so.
Before you get to answer, Mike, let Sid ask her comment because it's related.
I thought my question was for David and not for Mike.
Okay, you had 2. You had one for Mike as well, but okay, we'll leave it for David.
Okay. Well, David, so what I was interested in was you talk about the biological continuum and the social construction of life and death. And I'm just wondering if that's not just compatible with or saying the same thing as saying that brain death is a legal fiction.
I don't think it is, because I think the people who believe it's a legal fiction believe that there really is some real biological line to be drawn somewhere. It's just that this isn't the right place. Whereas I'm saying there isn't a, we want it's an understandable desire. It would be great if there were real things in the world that told us these hard lines, so we didn't have to have social constructions, but they just don't exist. They don't happen at the beginning of life to tell you this is right, and they don't happen at the end. And so and that's just not, it should be unsurprising that those things don't have. I'll just add one thing I forgot to mention in my talk. Bob Trug has tried to defend a kind of realism by saying, this was a talk I think at ASBH, if we just walked around and said we'd agree about which things are alive and which things are dead and so on. First of all, my wife clearly disagrees with you, because every now and then she says, do you think this plant is alive? And I have no clue, and she's the only one who can make that determination. But I also think, that back to the Linnaean classification issue, the fact that you can say this is a cat, this is a dog, that's a horse, it doesn't follow from that our classification of species correspond to real things that are not conventional categories. And there are good reasons why I think most people in philosophy of biology think these are really conventionally defined systems and classification systems, even though when we walk around, we can do a perfectly good job of saying that's a cat, that's a dog, that's a horse, that's a zebra.
I agree with all that. I mean, the UDDA is also socially constructed, like all laws are, and the DDR is also socially constructed. But the UDDA is also very explicit in what it says. It's describing what death is, and it is saying that, that the person with irreversible cessation of all functions of the entire brain, including the brainstem, is dead. They're making a claim there about death, which doesn't always fit the the diversity of socially constructed views.
But in a way, this is about what we do in response to that. As I said, I thought there's a more charitable interpretation of just saying it doesn't fit, and say that it's not obvious that it fits right now. And so we can reconcile this. And this is where part of the difference comes from. To me, that's a good reason for doing what I think Bob has suggested and Thad has suggested, which is we should try and bring those more in alignment by getting the law more in alignment with neurological practice. We have a thing that works. I've already suggested we have criteria that work really well and that satisfy all these things. And so it's a good line. We have a good way of drawing the line. It's just that the law that was written a long time ago might not fit as well as it as obviously as it should, given what we've come to learn over time. And so the law should be brought into closer alignment with medical practice, as opposed to thinking that it should go the other way around, and that we should let our metaphysics drive what the law should be, which should then drive medical practice. I think it should go that other way around. The medical practice with a line that conventionally works should drive how the law works, rather than the other way around.
So I want to call next on Alan and then Christos to ask you some questions, David.
I had to unmute myself there. No, I just wanted to make a comment regarding this idea of the lack of a bright line, because there are all these continuous observables in the process going from dying to decomposition. And we know from the theory of system dynamics that there can be state discontinuities that are not observable, but real state discontinuities behind the continuum of observable changes. So I think, all the examples that you mentioned about the biochemical changes being continuous and can't draw a bright line, that's all true, but it doesn't contradict the idea that there's an intrinsic discontinuity between endogenous opposition to entropy and the giving into entropy. That is a bright line, even if we can't see it.
Yeah, I'm skeptical of drawing lines that we can't epistemologically and say there is a metaphysical line, we just can't epistemologically ever know when it is. And again, if the question becomes, what's the purpose of why we're drawing the line and what role does it play in medical practice, in law, et cetera? So I just am skeptical of that. In terms of whether it exists or not, I think that is itself, whether this is a function of some kind of emergence or whether, I think that's actually more challenging in terms of knowing whether it's plausible, even biologically and metaphysically. Obviously, the debates about whether there are such things as emergent properties is an actual live philosophical debate, whether how much it depends on supervenience and other kinds of things that can be added to supervenience to be able to define those things. I would say that's entering into deep, muddy metaphysical waters, and we are best left, I agree with the things that Sean said earlier, that we're best left staying clear as much as we can from deep metaphysical waters when it comes to drawing lines that are this important.
Well, I would agree that you can't epistemologically say when that state discontinuity occurs, to the millisecond, but you can say if there is observable opposition to entropy, then you're on one side of the line. And if there's observable giving into entropy, you're on the other side.
I certainly don't dispute that there are clear cases in which we'd want to say certain individuals are alive and dead, just like I do want to say that it's pretty clear that there are certain things that are cats and dogs and zebras. But the question is, what is the classification system that we really need to optimally use for achieving the goals we're trying to achieve?
Christos?
Lenny, let me pass to Drs. Bernard and Trug. They've had their hands up for some time.
Okay,
and if there's remaining time, I'll take one.
Got it. Bob?
I think Jim was ahead of me, but okay, I'll go ahead and go. David, I will take it as a compliment that you chose to respond to my question even before I had a chance to ask it. So I'm just going to come back. I just don't get why you refuse to, or why you're pushing back against this idea that brain death is not biological death. And I'll say what you said, but I'll say it again. It's like, if you and I go out into the world and, we would have no disagreement about, okay, maybe your wife's plant, maybe that might be a borderline case, but for the most part, we're going to be able to agree on plants that are alive and dead, animals that are alive and dead, bugs that are alive and dead. I have great respect for the philosophical analysis that you've given here, but to say when you said folklore or something in your talk, it's not, to the average person to say, oh, no, I know that dog looks like it's dead, but I want to tell you, that is really just a social construct. That's an overlay on reality that we're putting here. Maybe you can make, let me finish, David. I've stood in the ICU. And you have too. I have looked at patients that are brain dead, and I will tell you, they do not look dead. Now, I'm with you that I don't have any problems with overlaying this concept of brain death, but I just don't think there's any problem with us saying that brain dead patients are not biologically dead. I think that is just sort of so intuitively the case that I just don't understand why you're pushing back against it. I'm done.
I don't think that the notion of what biological death is can be cashed out in a way that's meaningful, because this idea that there's going to be a sharp line. Yes, we can. I'm not saying the continuum isn't real. I'm saying that where we draw lines is a decision that we have to make, because it doesn't come built into us, and that there's no moment of death, and that the fact that we can say, we look at this unfolding, we look at all these things, and that people that we have to make a decision about whether we count brain death as dead. You look at them and you say, just intuitively, they don't seem dead to you. While we know that there are other colleagues in neurology who have clearly, we've seen this in the last 2 days, there are quotes from people saying exactly the opposite, that intuitively.
No, I don't think neurologists look at them and say they're biologically dead either.
There are quotes that have been shown in the last 2 days where people who clearly think they are, and who've appealed to this intuitive notion. So, so I just, the point is, it's at the blurry margins that matter. If you think that if you agree with the claim, that there is no clear definition and clear distinction between here is the moment of death, that there's no, whether it's brain death or circulatory death, that there's no clear moment where we can draw that line, that it has to be a decision that's going to be made about where we want to draw it. And so, and the fact that we can agree that's definitely dead, that doesn't change the fact that where we draw the line in the middle is actually something that has to be a decision to be made.
All right. I think the thermodynamic theory is a pretty good place to draw the line, but we'll stop here.
Jim?
Thank you. I want to make an observation and then I have a question. The observation is that both of the speakers were assigned to talk about the dead donor rule and really talk more about the validity of brain death, one from a physiological standpoint and the other from a theoretical biological standpoint. And David, your talk was really excellent, and I think it's given me a lot to think about. One of the questions that occurs to me in this recurring theme that we have about violations, alleged violations of the UDDA, represented by considering preserved hypothalamic neurosecretory function, is what is the work done by the second or the final sentence in the UDDA that has been given very little analysis in our two-day meeting. And that is that the determination will be performed according to accepted medical standards. And more specifically, the question is the work that does. My understanding from Alex Capron is that was inserted to try to basically defer to the medical profession on decisions about satisfying the criteria for the UDDA and not stipulating what they are in the statute, but allowing physicians the evolution of medical practice to make that determination. For example, one could argue, I think, that if accepted medical practice is to ignore the neurosecretory hypothalamic functions that Michael Nair Collins showed through his physiological lecture were clearly brain functions, yet it was accepted that those wouldn't be considered. Does the statutory language allow that? And would a determination such as that made by the people in the American Academy of Neurology who assert that the hypothalamic functions don't matter, are they permitted to do that by the statutory language?
Can I address that? I think that that issue has to do with the diagnostic tests. So the statutory language doesn't want to say that you should use a Doppler, or doesn't want to say that you must use an EEG, or that physicians must test these cranial nerve reflexes, but not these others, et cetera. So the diagnostic tests are deferred to medicine, but the category, the nosological category, the physiological criteria, the legal criteria, they're all the same in this context, is not deferred to physicians to decide what that is. The law has defined it as irreversible cessation of all functions of the entire brain. We defer to physicians to identify, given some particular patient, do they fall in that category or not? Since we know over the last 30 years, and the evidence is growing, that there are examples of patients who would be declared to be dead by neurological criteria after correctly following the AAN's guidelines, yet could have some preserved brain function. we have to acknowledge that as a false positive misdiagnosis of the legal category that physicians are tasked with identifying.
I think it remains unclear to me what the statutory language says. The determination implied of the above will be performed according to accepted medical standards. What is encompassed in that determination? So I wonder if one of the law professors who's knowledgeable about statutory language and its interpretation might want to comment on that.
Thad and I have talked about this, so Thad, yeah.
Let me. So I think you're definitely wrong, and here's why. The way in which we interpret statutes, and these are well-settled rules in every state as well as England, so these go back hundreds of years, is we don't interpret a statute in a way that makes language superfluous. And if I hear you right, you want to read the UDDA to say a person is dead who is determined dead according to accepted medical standards, right? But it doesn't say that. It says you're dead if there's been complete or irreversible cessation of all functions of the entire brain, period. And then the second sentence says the determination must be made in accordance with accepted medical standards. So your interpretation, which is, yes, this is what the AN reads it the way you just said it should be read, but they're also wrong because that completely negates all of the content of the meaning of the first sentence. And we don't interpret statutes in a way that makes language, which ignores language in the statute.
So what happens if the accepted medical standards are not what the statute requires?
Well, that's why you have a case like the Aiden Hailu case go to the Nevada Supreme Court, basically striking, saying your standards don't follow the statute. The Jahai McMath case also goes up to the Supreme Court of California, right, saying, right, that your standards, the AN standard, or those weren't, she was a child's, but it was the same standards. The pediatric standards don't follow the law, the UDDA of the state of California. So that's what happens, right? Is the courts will rule in favor of the families and enjoin, right? Issue an injunction preventing the withdrawal of organ-sustaining treatment because they really haven't been properly determined dead according to the law, because the medical criteria don't satisfy the law. So that's what happens. You have cases like that.
The legislature creates a statute that refers to the AAN's guidelines. Isn't that what Nevada did?
Yeah, unfortunately, I think Nevada screwed up because in my presentation, I said that there were, these different problems. One is, what are the accepted medical criteria? That's one problem. And then a separate and different problem that we heard about a lot in this conference is the mismatch, okay? Nevada only solved the first problem, which is, do we follow the original Harvard rules? Do we follow the AAN rules? Do we follow, this particular institution's rules, which deviate from the AAN standards? They solved that problem. Which criteria are authoritative? In the revision to the statute, they didn't solve the other problem that the standards don't match the law.
But that in a way, it can't be completely divorced. And I agree that we should change the UDDA so that it's more clearly consistent with the actual practice of neurology. However, it's not that these are like totally disconnected or two totally disconnected thing. And moreover, the ANN has said and stated their belief that the current medical practice, in fact, does do those things. Now, there can be arguments either way about whether that's really true or not. But if there's a deference to the opinion of the medical profession in the statute, it would be open to judges to interpret it that way. And I would say, especially given the potential political, practical social consequences of the decisions, I think it's an open question how judges are going to act. And certainly in the Jahi McMath case, the judge in the end did rule that they could withdraw life support, and then they had a negotiated agreement about how that was going to happen. And so I would say it's not at all obvious to me. I mean, we saw what happened in Nevada, but that doesn't follow from there that all other states are going to, right now it's, I would say, ambiguous, which is not ideal, but it's not clear that courts are always going to go one way or the other.
So I'm going to take the prerogative, since we're over, to have the last question to be asked by our hero of the conference, Christos. You've organized us. You have a question. You get the last word.
I take that. I just wanted to ask David Magnus. I think his talk was very compelling about making a case about a construct and why a line has to be drawn somewhere, and biological death cannot be. It's not a there's no realism there. But I struggle with the point where he said no in terms of transparency and preserving the status quo. And I don't know what the right answer is there. I mean, I share the idea that there is risk. However, death is not pneumonia, so it's a matter of basic justice, and so maybe it falls in a category where, again, within a liberal political frame, in order for law to be legitimate, it has to meet different set of criteria. It has to be publicly justified. So, thank you very much again.
Okay, I just say, if you're willing to say the same thing about COVID, and that you think patients should all be told and explained about the complexity and the social constructions of nosologies, which I think would be very dangerous. But if you think that that is in fact an obligation and what people ought to be doing, and that it would be problematic to pass a lot of laws if down the road it turns out we want to have mandatory vaccinations and things like that, we shouldn't be allowed to really do that, because for some people they may not believe that, because they might have different views about this socially constructed category of disease. If you are willing to go all the way, then I'm okay. But to me, saying this thing that's socially constructed, we have to be transparent about, and say that COVID doesn't matter, vaccination doesn't matter, those other things, I think it's wrong. I mean, then it's if the only difference is, as Michael said in his article, is this thing is really more important, then something, then the minute it rises up in 2018, yeah, you could say it about influenza. I don't think you can say that about COVID. And so then when it rises to the level, then we have to be transparent. I would say that's exactly the opposite of what we would want, because I think most of us would be worried if we had a lot of conferences like this about nosology and it was used by people who were opposed to the idea that COVID is real and who were trying to fight any kind of obligations to be vaccinated.
So I want to thank all of the panelists, attendees, and the Neubauer Collegium staff. Thank you, Jessica and Mark, for two incredibly stimulating days. Did we solve all the controversy surrounding death? No. Did we make some progress? I believe so. I know we didn't address all the questions in the chat box. I wish there had been enough time and the opportunity to talk in small groups, as would have happened in an in-person conference. I know I speak for many on the panel to say we would be happy to continue the conversation in both formal and less formal ways. Find us by email, find us on Twitter and everywhere else. So thank you all for attending. Thank you again to the panelists. I'm going to ask the attendees to leave the conference and for the panelists to remain for a few minutes. Thank you very much.